just put your phones on silent, if you wouldn't mind, and to let you know that public comments made during this meeting are audio and video recorded and shall be part of the record, which will be retained according to the town's procedural bylaw. And if you need to know more about that bylaw, you may contact the clerk's office. So the first thing we need is approval for agenda for our special meeting for January the 9th, moved by Councillor Nicol, seconded by Councillor Waters. Any additions or changes needed to the agenda? Seeing none, all those in favor? Opposed? That's carried. Are there any disclosures of pecuniary interest on this special agenda for tonight? Seeing none, we'll move forward. So our first item of business is to welcome a special guest, as we've done for our first meeting and will continue to do for a few months at least, is continue with our education on different aspects of municipal government that we're going to have to deal with. So tonight, we welcome Sid van der Veen to come and give us the Drainage Act 101. So Sid's been a drainage coordinator at the Ministry of Agriculture, Food and Rural Affairs, OMAFRA, for over 27 years. And Sid is responsible for the provincial administration of the Drainage Act, which includes liaison and guidance to municipalities and engineers, environmental agencies, industry groups, and private property owners. And I can tell you, we have called on Sid numerous times over the years to come and assist us. And every year that I've been on council, we've had a Drainage Act refresher for every new council. So I really appreciate all the time that you've given us over the years. Sid provides training and administration of the Agricultural Drainage Infrastructure Program in Ontario, and he is highly acknowledged in the drainage world as the expert in drainage. And it's my understanding that this will be his last presentation as the drainage coordinator for OMAFRA, as he retired this past December. Congratulations to you, Sid. Both council and staff want to thank you for presenting here today, taking the time to do that for us, and all of the assistance that you've given us over the years. And I'll turn it over to you.
Thank you. I'm going to be giving an overview of, first a bit of an introduction into drainage and drainage conflicts, and then tools that we have in Ontario to solve drainage problems. And then I want to talk a little bit about management of municipal drains and specifically talk about some of the responsibilities assigned under the Drainage Act itself. One of the questions people often ask is, why do we have a Drainage Act? What's the purpose of this? There are other jurisdictions that don't have a Drainage Act, and so what responsibilities do municipalities have when it comes to drainage issues? Well, when it comes to drainage issues, clearly, if it is an activity under the Drainage Act, the municipality has a responsibility to act, and I'll get into some of those details later on. And that's usually performed primarily, obviously council is the central role, but the drainage superintendent implements many of the functions of the Drainage Act. When it comes to drainage of roads, that's a roads department or public works responsibility, and there may be other statutory requirements. Not sure what happened, but I'm going to keep talking. There may be other statutory requirements, but the point is, municipalities aren't really responsible for every drainage issue that's there in your municipality. You are only responsible for the ones that are assigned to you through some statute law, like the Drainage Act or the Public Transportation and Highway Improvement Act or the Municipal Act. But a private dispute between property owners is not necessarily your responsibility. So what do people like that do when they have an issue? Well, some of these issues result in disputes between property owners and legal action. And in that sense, I've got a few slides here on the common law as it relates to drainage. Now, common law is a word, basically a way of lawsuits between people on issues, and it can cover a variety of topics. The key one that I want to focus in on is drainage. And through a number of court decisions, the courts have indicated that there's kind of two sets of rules when it comes to drainage and drainage issues. Water in a natural water course and surface water. And they define it, the dividing line between the two as this definition of natural water course. So if it falls within this definition that I have up on the screen, then it's a natural water course. If it doesn't, then it's surface water. Why do you care? Well, the municipality as a property owner may have private disputes with adjoining property owners. So a roads department may have issues with their neighbor because the neighbor says water's coming off of your road and it's causing me drainage issues. You should address my problem. And so it's important to know where your responsibilities lie and where they actually end. Now, who decides on whether something is a natural water course or surface water? Really only a judge decides. So when it comes to water in a natural water course, riparian landowners are landowners that own land abutting a natural water course. And they have the right to drain into that natural water course. Now if you think about a natural water course, let's say Innisfil Creek where it's natural. And you say you own land abutting that natural water course, and you say you have the right of drainage. You'd probably think, well, yes, obviously, my water is going to go directly there. But really what it's saying is if you are not a riparian landowner, you don't have the right of drainage, and that's a common misconception. Most people in Ontario do not have the right, most property owners in Ontario do not have the immediate right to drain. They can acquire it, but they don't have it immediately. Only riparian landowners, owners who own land abutting a natural water course, have the right to drain. They have the right to use water for domestic purposes. They have to accept the water. They can be held liable for damages if they dam or block a natural water course, or if they modify or interfere with a channel of a natural water course that ends up causing problems for somebody else. They can be held accountable for that. They can be brought to court and charged for that, and could be held liable for damages. So what does that mean? Well, one example that I often use is a beaver dam on a natural water course. There are court decisions that say, well, a beaver dam is a natural obstruction on a natural water course. If you remove it and it floods somebody else, you can be held liable for those damages under the common law. Likewise, if somebody upstream has a pond that they appreciate and are using, and you remove a beaver dam, and that pond is removed, you may be removing a privilege that occurs to them naturally, and you could be held liable for damages. So there are real limitations on solving drainage problems under the common law as it relates to natural water courses. So this, to me, was a barrier or not a way of effectively dealing with drainage issues. So when it comes to surface water, what the courts have said, and I kind of hinted at this earlier, surface water has no right of drainage. Essentially, the courts have said surface water, as long as it's not in a natural water course, doesn't have the right to flow downhill. Again, that's the court's determination. That's not mine. That's not the Drainage Act. The courts have said surface water has no right of drainage, and I can show you court decisions where these principles have been fulfilled. There's no liability for water flowing downhill over the surface of the land, but the lower landowner doesn't have to accept that water, and they can put up berms and dikes. However, if somebody collects or concentrates that water by means of a tile drainage system, an agricultural tile drainage system, or by means of a road with a ditch and culverts, or eaves troughs or downspouts, or you name it, any way that you collect water, if you collect water and direct it onto somebody else, then it could potentially be a position of liability. And again, we have all sorts of situations like that where we collect surface water. The blessing that Ontario has is also its curse. We have an abundance of water, which is fantastic, and I don't want to diminish it, but we need to deal with the surplus of water, and so we build drainage systems. We build culverts and roadside ditches and eaves troughs and downspouts and tile drainage systems, and all of these things need to be brought somewhere. How do you get a place where you can discharge, though, without causing problems to your neighbor? How do you avoid this liability? How do you, on a natural water course, remove a beaver dam without being sued for the damages? And it was these things that resulted in a Drainage Act being passed, and that's why it was there. It was really intended to provide a means of addressing common law drainage problems in a communal fashion. And there's two ways of doing it under the Drainage Act. There's something called mutual agreement drains, and then there's petition drains, which we often refer to as municipal drains. The end result is a municipal drain. I'm going to talk very briefly about mutual agreement drains. It's a tool that can be used by municipalities to solve drainage problems fairly quickly, cheaply, inexpensively, but it depends on agreement. And so usually it's one or two or three property owners that are involved in agreement, and they agree that this is what's going to be done to solve the problem. They write it up into a written agreement, and the agreement gets registered on the land, and it becomes binding on the property. So it's a form of contract bound to the property, and so it becomes binding on any future property owners as well. Again, this is a tool that are sometimes used by roads in order to get outlet across an adjoining property, or it could be between private property owners that they agree between themselves that this is what we need to do in order to solve a drainage problem. Normally, quite often, they only go to the verbal agreement or written agreement part, which comes with some limitations. But the best way for implementing this tool is to go to the agreement registered on property title. So now I want to talk about the petition drain process. The petition drain process is a process that the end result is a municipal drain. Now, there's also something called improvement projects under the Drainage Act, which the South Innisfil Creek is. And because the process for improvement drains is very similar to the process for petition drains, you'll see throughout the next few set of slides that I've tried to duplicate or identify where the process differs slightly. But I'm going to be talking about petition drains, new drains, and then indicating how there's slight variations for drain improvement projects that are done under Section 78 of the Drainage Act, which is, again, a process that allows municipalities to make improvements to existing drains. So, first of all, for new drains, all new drains must be initiated by a petition of landowners. So the Act says if we have a group of property owners that have a drainage problem, and they sign a petition, which is a legal document, and the petition is signed correctly by the property owners, that will trigger the start of the Drainage Act process. And petitioners become financially responsible as soon as they sign a petition. So that's how new drains get started. It's not by council's initiative. In fact, I would suggest council should not be starting new drains. However, if the drain exists, like the South Innisfil Creek, what the Drainage Act says is council may undertake drainage improvement projects at the request of property owners, or drain improvement projects can be requested by property owners, but they are only undertaken if council decides that this is the thing to do. So that comes from Section 78 of the Drainage Act. The South Innisfil Creek project was slightly different in that it wasn't initiated by council, but it was initiated on the order of the drainage referee about 10, 12 years ago or so, somewhere around there. So it's a bit different, but in the same sense, because of the referee's decision, it was ordered that the municipality proceed to undertake this improvement project on the creek. But otherwise, all projects are other than this exception, projects are either initiated by petition for a new drain or on the instruction or bylaw or resolution of council under section 78. So now this is specifically for new municipal drains. Inside a watershed is an internal area requiring drainage. And for it to be a valid petition to start a new drainage project, the petition has to be signed by a majority of property owners in that area requiring drainage, or the owners that represent at least 60% of the land in that area requiring drainage, or where a road requires drainage, then the road authority can sign the petition. So MTO could sign a petition for Highway 400 or your municipality, or the county of Simcoe could also sign a petition if they had a road that required drainage. And then the last one, the director of the Ministry of Agriculture, Food and Rural Affairs, where there's agricultural land involved, and that isn't used very often. None of these criteria apply to Section 78 projects because, again, for an existing drain, because it already exists, all council has to do is be convinced that the drain requires an improvement, and they can appoint an engineer and undertake the project. So this is, again, the early stages of the process. Here's a few examples of valid petitions. So here's a area requiring drainage, and there's a watershed boundary there, and the petition has been signed by these 4 property owners. Because it's 4 out of 7, it automatically becomes a valid petition. It's not council that determines the area requiring drainage. It would be the engineer that's appointed by council that would do that. Here's another example of the greater than 60%. So in this case, you have a property owner and the 3 property owners, even though they don't meet the 50%, they do meet the 60% of the area, so it becomes a valid petition. And then the final one is this situation where a road, nobody else is asking for it, but the road says we need a new drainage system because we've collected water. Maybe you've done a road improvement project and you're now putting more water onto a downstream property owner, and they go, we need to get a legal outlet here. You can sign a petition to get a drainage system going. Again, none of this applies to drain improvement projects. So now this petition comes in. What's the role of council? Council can reject a petition for a new municipal drain, but that decision is appealable to a body called the Agriculture, Food and Rural Affairs Appeal Tribunal. So you need to have a valid reason for saying no to a petition. To say that we don't think it's necessary is not good enough, because obviously somebody knowing that they're financially responsible has signed a petition. It's not good enough to say that we don't think it's good and valid or cost beneficial. Or if you think we're concerned about the environmental impacts, well, there's a couple of processes under the Drainage Act where you can ask for either a benefit cost statement or an environmental appraisal to help you in your decision. So normally, usually the petition is accepted and it starts the rest of the process. Council does not decide if the petition has met one of these criteria here. Again, that's the very first job of the engineer that's appointed by council. The petition, along with some basic information, is circulated to the local conservation authority or Ministry of Natural Resources and Forestry for comment. We also recommend that you start including the Fisheries and Oceans for their impacts. And these agencies may also request an environmental appraisal. So now most of this is not applied to improvement projects other than if there's an improvement request, it's usually circulated to conservation authorities or Ministry of Natural Resources and Forestry for their comment as well. So again, if it's an improvement project, there is no petition. So now an engineer is appointed. If the petition is accepted, and this applies to both new drains and also improvement projects, council appoints an independent engineer. And there's the numbers at the end of the text here is references to sections of the act. So the council is required to appoint an independent engineer that has to be fair and impartial. There's a whole section on the engineer having to be impartial, serving the community of landowners. And the appointment is done by bylaw or resolution. The reason for that is the bulk of drainage systems are constructed on private land for which the municipality eventually acquires a right-of-way. But the work is done on private land originally. So the appointment by bylaw allows the engineer and the engineer's employees to go onto land to do whatever surveying is necessary. So this is a key one that is really important. And then working with the engineer, the clerk sends a notice of an on-site meeting out to the property owners. Now I'm just going to scroll back a little bit here. What the act says is only the people within that the area requiring drainage are required to be notified of the meeting, the on-site meeting. We usually recommend invite too many rather than too few. Let them know that there may be possible project in the area and that they may be impacted. So this is this on-site meeting. At the on-site meeting, the engineer's responsibilities are determine for a new drain, determine the validity of petition, and again, that doesn't apply to a Section 78 project, and then determine the needs and concerns of both the property owners and agencies. So if the property owners are saying, we get flooded 3 times a year because of water that's coming from my neighbor or from the road or whatever it is, these are the things that I want to address. Or I want to farm my land more effectively by putting in a tile drainage system and I don't have an outlet. Or it could be the road has road issues and we need improved drainage, and so we need a better outlet for the drainage coming off of the road. All of those things the engineer would collect to determine what am I trying to design for, and that's the key elements of the on-site meeting. The next thing is if council decides, council can instruct the engineer to prepare a preliminary report. Again, a little bit different for the South Innisfil Creek because in the South Innisfil Creek, a preliminary report was ordered by the referee, and so the report was produced, and it was not considered by council, I believe. It was considered by the referee, who directed some actions as a result of the preliminary report. But normally, council instructs the engineer to prepare a preliminary report, and it's optional unless a benefit cost statement has been requested or an environmental appraisal. And this preliminary report allows different options and costs associated with those options to be explored. So there may be different ways of solving a problem, different routes that a drain could take, or different forms that the drain can take. And all of that would be identified in the report, and the engineer then files a preliminary report, and a meeting to consider this preliminary report is held. Now this process, or this component of the process, is identical whether it's petition drains or Section 78 drain improvement projects. There's then a meeting to consider the report. A copy of the report must be sent to everybody within the area requiring drainage, and again, consider sending it to everyone within the watershed. At this meeting, the meeting is usually chaired by the mayor or head of council. The engineer will give an overview of the report and usually with a recommendation, and then the owners, particularly those within the area requiring drainage, those that have the problem, have an opportunity to provide input to council's decision. And so council has to decide at the preliminary report, or actually there's 2 parties that make a decision. For new projects where there's a petition, the owners within the area requiring drainage have a right to add or withdraw their names from the petition. If after this process, the petition is no longer valid, the process stops and the original petitioners pay the costs incurred to date. Now, at this point, it's not significant because it's usually just a preliminary report, not significant engineering costs. The ability to add or withdraw names from a petition obviously does not apply to a Section 78 improvement project because there is no petition. Then the second party that makes a decision is council. Council can decide to proceed or not proceed, and in which case petitioners or property owners can appeal to the tribunal. And if the council decides not to proceed with the project, then the municipality pays the costs incurred to date. So the project stops, municipality pays the costs incurred to date, and the project dies. However, if an appeal is filed to the Agriculture, Food and Rural Affairs Appeal Tribunal, then the tribunal can reverse that decision and order the council to continue on. Assuming it moves past the preliminary report stage, then the engineer is directed to prepare a final report. And these are items that are specifically identified in the Drainage Act that must be included as part of the cost of the project, or part of an engineer's report. Plans, profiles, and specifications. Now, I understand with the South Innisfil Creek that there's a Highway 400 crossing. That makes things difficult. That's not exactly easy. So the plans, profiles, and specifications, it's 3 little words, but that could make it far more complex than the 3 little words imply. The Act also says you have to provide a description of the area requiring drainage. Please note that again, for an improvement project doesn't apply because it's an improvement project. Total cost estimate, the engineer's report, which I believe has not been filed yet, right? So it will include a total cost estimate. It'll also include an assessment schedule, which shows how the costs are divided between the various property owners and agencies involved. There's also allowances, which is compensation provided to landowners for land taken or land lost or damages or an impairment of the use of land. And I'm thinking about a drain that might cut off a section of land and make it less effective. So those are all compensation figures that the engineer would provide. And the engineer has to provide things, specific items such as benchmarks, which are elevation points or specifics on how material is going to be disposed of, crossings, working space. All those areas are all included in an engineer's report. So along with that, the engineer can't lose sight of the fact that the property owner's issues need to be resolved as part of this. What started the project? What are we trying to resolve? Back what we learned from the on-site meeting. And the other thing that the engineer needs to do, which is becoming increasingly more complex, is obtain approvals from agencies like Ministry of Natural Resources and Forestry for endangered species, or Fisheries Act for fish species, or the Conservation Authorities Act for flood and fill line regulations. So those are just some of the examples of the approvals that may be required, but all of that gets included into the final report. And again, all of this, other than the description of the area requiring drainage, applies equally to petition drains or improvement projects. Here's just an example of a very tiny municipal drain. The dark line that looks like it's going through the bush, that's the drain itself. The dark circular line is the watershed area. So every one of the property owners within that watershed area is going to be assessed. And the engineer will show who owns the property and the lots and concessions and that sort of thing. Other features such as roads and railways. The engineer will also include an assessment schedule. So again, this is a really small drain. So if you again look at this, there's only a few property owners. Well, each of those property owners are being assessed for this drainage project, including, if you note, 6th Concession Road. I know the print is small, but the road itself is being assessed a share of the cost. In fact, their net assessment is $29,500, which is roughly half of the cost of this particular project. So they may have been one of the petitioners on this particular project. So all of that gets wrapped up into a final report. The report is filed with the clerk of the municipality. And once it's filed with the clerk of the municipality, council instructs the clerk to send a copy of the report and a notice of a meeting to consider the report to all the affected property owners, any other involved municipalities, and then agencies such as Conservation Authority, Ministry of Natural Resources, road authorities, public utilities, railways, and OMAFRA as well. At this point, OMAFRA really has had very little involvement, but we are usually sent a copy of the report because ultimately later on you're going to be applying for grants, and we do provide some grants towards drainage projects. And I'll talk about that a little bit later on. Then there's a meeting to consider the final report, the report that's just been submitted. Again, it's a council meeting chaired by the mayor or head of council. The engineer usually gives an overview of the report. Participants are allowed to provide input. They can try to influence a decision of council, and I'll talk about what council's options are in just a little bit. It's not an opportunity to object to assessments. You'll see that there are various appeals stages later on, and that's where you can appeal assessments or the technical merits. But the participants can say, we think that the drain is not adequately designed, or it missed this part of the watershed, or whatever, how it hasn't addressed whatever the engineer was assigned to do in the first point. At this meeting, then, there are two bodies that, again, make a decision. The first is the owners. They have, again, for a new drain, they have a right to add or withdraw names from a petition. And if it's no longer valid, the original petitioners pay costs incurred to date. Notice, this does not apply again to Section 78 because Section 78 improvement projects are initiated by council, or in the case of South Innisfil, by an order of a court. So that really doesn't apply here. The second option is council can decide to proceed or not proceed. And if it's stopped for new drains, petitioners can appeal to the tribunal saying, council stopped this and we want to continue on. Or for Section 78, if it was a request from a landowner, then the owners may be able to appeal to the tribunal as well. And if the project is stopped, the municipality may be ordered to pay or may be left holding the cost of the project, especially for if council decides to stop it and it's a new drain, then council will be left with the costs of the project to date. If it's an improvement project, normally it's not stopped because it's council that's initiated it. In this case, in South Innisfil Creek, where it's been ordered, I don't know that you actually have the authority to stop this particular project because there is a court order. So now, council's role at the meeting to consider the report. Council can accept the report, give 2 readings to a bylaw. They can, if they think that there's things missing in the report or things that the engineer needs to change or address, they can refer the report back to the engineer for modifications, or they can do nothing. And I kind of addressed this because the South Innisfil Creek has been ordered by a referee. I'm not really sure that that's an option that's available to you. Council cannot modify the report of the engineer or direct the engineer on how to solve the problem. And you may say, well, why can't we direct the engineer? Well, would you tell the engineer how to size a girders on a bridge? Part of this is engineering design, and if you influence or try to influence how the project is designed, the engineer is no longer independent and impartial. So if council gives 2 readings to a bylaw, it essentially means we agree in principle with what's in the report, subject to the appeal stage that follows next. So there's 3 appeal bodies that are established under the Drainage Act, and I've talked about some of them already. The first is the Court of Revision. This applies both to petition drains and improvement projects. Court of Revision is appointed by the municipality, and in order to be eligible to sit on a Court of Revision, they have to be eligible to be elected to council. Many municipalities use council members as the Court of Revision members. There's no requirement for that. Again, the only thing that the Act says is you have to be eligible to be elected to council, so I think you need to be a ratepayer in the municipality, and you probably can't be a municipal employee. Beyond that, it's pretty much open. There's a whole lot of guidance in the Act and also in the fact sheet or info sheet that I reference up there, and I talked to Jeremy, and he does have a copy of these procedures, the info sheet. But some of the other things that are important to understand is the Court of Revision is made up of either 3 or 5 members, and they hear appeals as a panel together. And they are not council, they're not a committee of council, they are an appeal body. So they make decisions independently, strictly on assessments. Now, what are the types of assessments, appeals that they can hear? So the important thing for council to understand is, back when we were talking about the meeting to consider the report, you don't deal with assessment appeals at this meeting. Your instruction would be, no, we're not going to deal with that because it is going to be dealt with, assessment appeals are going to be dealt with by the Court of Revision at a later date, where the court will hear appeals, the court will hear the engineer's explanations, and then the court will make a decision on the particular appeals. The next appeal body is the one that I've referenced a couple of times, the Agriculture, Food and Rural Affairs Appeal Tribunal. They are a provincially appointed appeal body that hears appeals under, I think it's about 15 different pieces of legislation. So I believe there in total is about 20 different members appointed to the tribunal. And when they hear drainage appeals, they will sit usually as a panel of 3 members. What do they hear? They hear appeals from the decision of the Court of Revision. So if a property owner says, I've appealed to the Court of Revision, I'm not happy with the decision they made on my appeal, they can then appeal further to the tribunal. They cannot directly appeal to the tribunal on assessments. So I've heard this from landowners before, I'm going to forego the municipal appeal body because I'm not going to get a fair hearing there. I'm just going to go directly to the tribunal. And my response is, be careful. The tribunal is likely not going to hear your appeal because they hear appeals from the decision of the Court of Revision. They also hear technical appeals. So if a property owner says, I think that the drain is under-designed or over-designed, or too much is given for allowances, or I don't like where it's located, or whatever the technical feature is, that can be appealed to the tribunal. These are dealt with under Section 48 of the Drainage Act, and it's very broad. It says things like you can appeal allowances, you can appeal on grounds that the drain should be modified on grounds to be stated, which is really broad, and also you can appeal on whether or not the engineer has said whether or not the drain is required. Even if the engineer says that it's not required, then there's an appeal there as well. Again, in a provincially appointed appeal body, so there's no cost to appeal to the tribunal, no cost. Obviously there is a cost, but it's paid for by the province, but there's no cost for filing an appeal to the tribunal. And the tribunal will usually hold the hearings in the municipal council chambers quite often. So they'd probably come here and the panel would sit up at the front and hear the appeals. I usually tell property owners that it's important to have your case made based on facts, so that, it's not just, I'm opposed to this drain and I think I'm paying too much. Well, that will get you nowhere. I'll just be upfront. You need to base it on a case that here's why I think I'm being assessed too much, or here's why I think the drain is not necessary, any of those types of things. So then the third and final appeal body is the referee. The referee is a legal appeal body. The referee is, again, appointed by the province and has almost all the same sort of authority as a judge. The referee's hearings are usually held in the local courthouse, so the Ontario Superior Court of Justice. And I strongly recommend anybody appealing to the referee to retain legal assistance. Now, what are the sorts of things that the referee would hear? Well, they might hear things that, such as the municipality didn't, we, the property owners, I as a property owner feel like the municipality didn't follow the Drainage Act, didn't abide by the requirements of the Drainage Act in implementing this project. Or we feel that this drain is not being brought to a legal outlet, the common law responsibilities. And so we're opposing the project for that reason. Or there could be any other myriad of things that they could appeal on from a legal basis. So really you're arguing law here, not technical features, law. And again, that's why I usually recommend help yourself by getting a lawyer if you're going to appeal that part of it. Those are the three different appeal bodies. After all appeals have been dealt with, and assuming that the project has not been set aside by one of the appeal bodies, then council gives third reading to the bylaw, and that then authorizes the construction, or in the case of a Section 78 improvement project, the improvement of the project, even across properties that might be opposed to the drain. Again, the Drainage Act, the whole purpose was drainage is not an individual thing. It affects a multitude or a community of landowners, and so the majority rules, or in terms of the area requiring drainage, so it could be forced across properties that are opposed to the drain. The cost after the project is completed can be assessed to the lands in the watershed of the drain, and now, again, for a new drain process, the culmination of the process is a drainage system that has legal existence and becomes part of the municipality's infrastructure. So it now becomes very different from, remember when I started earlier about a natural water course and beaver dams on it, and if you remove it, well, if there's a beaver dam on a municipal drain, you have an obligation to remove it. It becomes totally different. And I'll talk a little bit about that now in management of municipal drains. How am I doing for time? Sorry. Good? Okay. So the act, once a drain exists, it becomes part of your infrastructure. Even though it's predominantly located on private land, the municipality acquires a form of easement. It's not an easement registered on property title, but a form of easement in order to enter onto the land and perform the work necessary to manage this municipal drain. I'm going to focus mostly on maintenance and repair. I'm not going to talk about improvement because we've really dealt with that through the whole process. And then I'll talk very briefly on some of the other things that are in that list. So let's talk maintenance and repair. So here's the key section of the Drainage Act. So once a drain exists, the Act says any drainage works constructed under a bylaw passed under this Act shall be maintained and repaired by each local municipality through which it passes. So that first part says it's your responsibility. You have a duty to do it. And in fact, you could be held, there's another section of the Act that says if you don't do your job, you could be held liable for not maintaining a drain. But who pays? At the expense of all the upstream lands and roads. So when a maintenance project is done on a drain, the cost of that project is assessed back to the property owners in the watershed of the drain in the proportion identified in the report for that particular drain. So a few key notes here. First of all, it's a mandatory responsibility. There is, I covered this already, potential liability if the work is not done. The other key thing is with maintenance and repair, you don't need a new engineer's report. You're working off of the old report that has already gone through the communal process and is adopted by bylaw. And that engineer's report adopted by bylaw is really the law for that particular drain. So when your drainage superintendent undertakes maintenance on it, they must adhere to the standards that are in that existing report. And they must adhere, when it comes to assessing costs out, they must adhere to the proportions that have been identified in the assessment report that may have been modified by the appeal bodies. So the average project, just to give you an idea of the cost efficiency, the average cost of a project across Ontario under a new engineer's report is between $150,000 and $160,000 in that area. The average cost of a maintenance project is between $5,000 and $6,000. And it's because your drainage superintendent will open up the report that's already existing, will hire a contractor to do the work, do proper notification and that sort of thing, and then undertake the work. Now that's again average. A maintenance project could be the removal of a beaver dam at a cost of $200. That's a maintenance or repair project. Or it could be the clean out of 3 kilometers of drain at a cost of $50,000. I'm throwing numbers out here, but I want you to understand that that's the average. The other, well, I've already covered these key responsibilities. Assessment schedule updates. No watershed is static, and I know Innisfil is going through changes in the landscape, so there's severances and subdivision of land. When you have an existing assessment schedule that's adopted by bylaw, and now you have a number of severances, how do you deal with that? Well, there's a couple of sections in the Act that allow the municipality, and usually in the top two, council doesn't get involved very much, but there's a process in the Act that allows the assessment schedule in the report to be updated. And it could be done as a condition of severance as well. In fact, I encourage that. If the assessment schedule is very old and very, very out of date, sometimes they'll appoint an engineer to prepare a report strictly for a new assessment schedule, which I'm referring to as Section 76 of the Drainage Act. And it's generally the same process, but without all the technical features. It's strictly an assessment schedule. There's also connections. You have lands that change land use. So if you have a development that was agricultural land and now it's become an industrial subdivision or whatever, and it's generating more water, even though you're controlling peak flows, if the volumes of water are increased and going into the drain, then the Act says, hey, it's a user pay system. If you're generating more water and directing it into the drain, then you should be paying more as well. Again, back to the whole user pay system. And then there's a bit of a process that I won't dwell on right here. But again, the Act envisioned that the watershed is not going to stay static. There's going to be changes, and there are opportunities for dealing with those changes. Enforcement and abandonment. So there's an enforcement section that says no one may block a municipal drain, and the owner or occupant can be ordered to remove the blockages, and they can do it themselves, usually under the superintendent's supervision, or if they don't, the superintendent on the direction of council can do it, and the costs added to the taxes, because a blocked drain could have significant impacts on somebody else upstream. No one may damage a municipal drain. Well, you may say, how do you damage a drain? Well, somebody, if they have equipment of their own, may say, I don't like where this drain is located. I'm going to relocate it on my own. That's damage. I use the suggestion of, so how about if somebody decided to do that on a road? Would you object? Well, yeah. It's municipal infrastructure. You can't make changes to it on your own. It's not a private system, it is a municipal system, and the municipality can take legal action to the court of the referee against anyone who damages a municipal drain. You can abandon a municipal drain. Property owners can initiate abandonment through a petition process. Council can initiate abandonment, and then after it's abandoned, the municipality has no further responsibility. I always say, this is in the Act, be careful what you ask for, because these projects started for a reason, because there was a need for drainage, and once it's abandoned, no one is responsible. So if there's a beaver dam on there, I would suggest municipalities stay away from it. It's not yours anymore. It's no one's responsibility, and I fully expect that the complaints will come back after a period of time, and potentially even a petition to convert it back into a municipal drain eventually. So that's enforcement and abandonment. I want to talk a little bit about Drainage Act responsibilities. Municipal Council has the key central role or responsibility in the Drainage Act procedures. You'll see if you read the act, there's a lot of sections where it talks about the council's responsibility. Now, having said that, council doesn't go out and maintain drains, and council doesn't assess the cost out. They have those responsibilities are implemented through staff like the drainage superintendent or the clerk or treasurer. The clerk's role is coordinating much of the Drainage Act procedures. The treasurer's is more the financial part, the grant applications and levying assessments. And the superintendent, I'm going to talk about the superintendent later on. The first three are quite often staff members that are actually responsible for these components of council's responsibilities. But some of the responsibilities are also implemented through retained services such as the contractor and the engineer, both of who are retained for a specific purpose, and once they're done, their responsibilities with the municipality are done as well. I want to talk a little bit more about the drainage superintendent. Superintendent is appointed by bylaw, and again, similar to the engineer's appointment, the appointment by bylaw provides the power of entry onto land to be able to inspect drains, which is important, to also undertake maintenance and repair projects. The superintendent is also responsible or can assist the engineer in construction or improvement projects, and they're also directed to report to council. And the cost of a superintendent is charged to the general funds. For a new drain or a drain improvement project, the engineering costs become part of the cost of the project. For maintenance or repair, the superintendent costs are charged to the general funds of the municipality, not to the project itself. So that's one of the reasons why maintenance or repair projects are significantly less. Grants. So we have a grant program under the Drainage Act that has been around for a long time. And I'm not going to spend a lot of time on it, but essentially we pay grants towards assessments on agricultural land for drain construction or improvement projects, and also for drain maintenance and repair projects. So when your superintendent performs a maintenance or repair project, they will apply for grants at the end of the year. We also pay a grant towards the municipal costs of employing a drainage superintendent. So your superintendent, the cost of employing your drainage superintendent is paid 50% by the province. There are a number of rules and policies around the application or the claiming these grants. I just added one: the work has to comply with law, which is kind of a motherhood statement, because if you do a project that doesn't have the approval of the Conservation Authority or Fisheries and Oceans, we're not paying grant. And I think that's kind of again, a motherhood statement, why only makes sense. Summary: municipality administers the Drainage Act process. The process provides an opportunity to solve private drainage issues. The advantage of the petition drain process is you have an independent third-party engineer and you're getting a professional design. There's cost sharing that's recommended using the sections of the Drainage Act recommended by that independent engineer. There's also compliance with other legislation. I didn't talk about this, but the definition of drain or drainage system can be pretty broad. It can be a channel or a pipe, but it could also include water control structures. It can include dikes and pumping stations. There's a legal means of recovering costs. There's a right of access to private land, and there's independent appeal bodies. And once it's built, there's an opportunity for future maintenance or repair. So to me, all of this are advantages of having nothing at all, where you go, as a municipality, you would go, well, if it's not a municipal drain, it's your issue, it's not ours. It's not that you even are avoiding the responsibility. You have no authority, you have no ability to deal with it unless it's a municipal drain system. So I think that's it. There's some reference material that I included in there. I think that's it.
Thank you very much for that, Sid. Much appreciated. And I was remiss in not introducing our drainage superintendent, Jeremy Ninehouse, who's done a great job bringing our drains up to snuff. And now I'd pass it over to council for questions. Councillor Fowler.
In regards to abandonment, does it revert back to a natural flow pathway once the municipality, washes its hands of it, for lack of a better term?
Really good question, which is code for, I'm not really sure. I'm serious. I've been asked this question before. It can't be natural because it's already been modified, but it's not subject to statute law because the Drainage Act makes it very clear that once it's abandoned, the municipality is no longer responsible for it. So I don't know for sure, and that would be a legal test in the courts of whether or not something would go back to riparian rights, for example, or who's responsible and all these sorts of things. So it sounds like such a simple question, but there's not an easy answer for that one.
Thank you. A follow-up? Anyone else? Councillor Ices.
Yeah, so this is maybe just an aside, but as a farmer in Ontario, we have benefited greatly from the Drainage Act. A lot of other jurisdictions do not have the right to improve the way they farm, and this is all enabled by the Drainage Act. So it's interesting to see how this applies municipally, but this is a very good act, good government for farmers.
Thank you, and if I may respond to that, I'm biased, I agree, but I would make it broader than just the agricultural community. We've had drainage projects across Ontario that involved zero agricultural land, but it was drainage issues that in urban areas, some commercial areas. The act is being applied now, or they're trying to apply it in the city of Mississauga to try to incorporate water retention on the landscape. So there's different ways of solving it. Its initial purpose, its initial reason why it was passed was to provide the agricultural community with an outlet to farm our land more effectively. And again, I don't want to dismiss the importance of water, but we live on the leeward side of the Great Lakes, and we get a lot of rain and precipitation, and we need these drainage systems in order to farm effectively. So I completely agree.
Thank you. Any other questions? I had one, if I might, and that was in regards to the Court of Revision. Mm-hmm. So if I'm to understand, if it's members of the either council or members of the municipality, who would provide the technical assistance, the administrative support that group would need?
Yeah, I would suggest that, sorry, Jeremy, I'm going to put you under the bus there, but I think the superintendent is probably the best source of information for something like that. I do know your neighboring municipality, when they undertook the Holland Marsh drain improvement project, they had a special training session that they put on strictly for their Court of Revision members because they were expecting dozens, if not hundreds of appellants. And so they actually put on a training session. But normally for most drainage projects, there might be one or two appeals and they're dealt with. And that's actually one of the reasons why council quite often does it, because they have over experience, they've accumulated some knowledge of the Drainage Act, and as such they can come to the Court of Revision and better informed. The key thing with if council serves as Court of Revision is to make sure that they understand that when they serve as Court of Revision, they are serving as an appeal body and their council hats are off.
Understand. And so if it's members of the citizens of the community, is there remuneration? And if so, does that get added to the drain, or how does that work?
Yeah, good question, and something that I didn't cover. Yes, there is remuneration. So what the Drainage Act says is council members do not get paid for special Drainage Act meetings. such as the meeting to consider the report or their role on quarter revision. However, if there's members of the public, then they can be paid and the cost is added to the cost of the drain.
Thank you. And then my final question is in regards to, because I assume we're going to be in a position that we're going to have a lot of court of revision appeals or whatever they're called come forward. But as far as just people who move into a home, there's nothing on title about the Drainage Act. They've moved here a year ago. They get submitted this bill. They haven't got a clue what it's about. Is there, other than us doing the Drainage Act 101 for new residents, is there no way to actually require that it be a notice on a sale of a home?
So I'm going to answer this question by saying the Drainage Act doesn't require it. So that's the legal answer. Does that mean that you can't do it? I would suggest no, you probably could register it. Now here's the downsides of registering it. Number one, there's a cost associated with registering all these documents on property title. Number two, I talked about severances and splitting assessments, and now you would have to change those registrations. It's very dynamic. And similarly, and maybe this is my number three, what do you do with land use changes and assessments that change that way as well? So I don't know what the history was. I've been asked that before. How come it's not a requirement? I've always assumed that because it was predominantly used in agricultural areas and predominantly the agricultural community understood the need for it and that it was going through their land, that they didn't need the registration on property title. But again, the nature of drains is changing, and maybe that is something that councils want to look at. But my first answer is the one that really is the one that I need to stick with, and that is it's not a requirement of the Drainage Act.
I want to thank you very much for being here and helping us with this. And I know it's a very snowy night, but there are a few members of the audience here who might have some questions. Unfortunately, we have to go. We have a very long night ahead of us, and we have another meeting to go into right now. But if you and Jeremy wouldn't mind sticking around for a few minutes to allow some one-on-one with some of our residents, that would be very much appreciated.
Will do.
Thank you very much. And I'd ask council then for a resolution. The recommendation is on the screen. Can I have a mover and a seconder? Councillor Ices, Councillor Fowler, all those in favor? That's carried. And now consideration of a resolution to go into closed session for the items appearing in front of you on the screen. A mover, Councillor Van Berkel, seconder, Deputy Mayor Davidson, all in favor? That's carried. So we will go in camera now and come back out shortly before 7 o'clock. Thank you for everybody who came to our Drainage 101 workshop. We appreciate your attendance. session so we can move into our regular council meeting on time. So a rise and report recommendation, rising from closed session, moved by Councillor Nichols, seconded by Councillor Van Berkel. All those in favor? Those opposed? That's carried. Next is the closed session item number 1 regarding the appointment of local board employees. In this case, it's our committee of adjustment for the upcoming term of council. The names that are on the screen. A mover and a seconder, please. Moved by Councillor Fowler, seconded by Councillor Arsetti. All those, just before I say that, I just want to thank everybody who applied for Committee of Adjustment and for putting their name forward, and to thank those who are serving for the next 4 years. All in favor? That's carried. Next, a recommendation for the confidential direction given to staff on the LPAT appeal for Summer Place. Moved by Councillor Nichols, seconded by Councillor Van Berkel. All those in favor? That's carried. Next is confidential direction given to staff for appeal on 980 Isabella Street. Moved by Councillor Fowler, seconded by Councillor Waters. All those in favor? Carried. And finally, for our community planning permit system be confirmed. That was received for information. Moved by Councillor Arsetti, seconded by Councillor Fowler. All those in favor? That's carried unanimously. And finally, the confirming bylaw for the special council meeting January the 9th. Moved by Councillor Ices, seconded by Councillor Van Berkel. All those in favor? And that is carried. Move for adjournment. It's now adjourned. Do I need a recommendation for that? Sorry. Moved by, who's adjourning? Councillor Payne and Councillor Nicol. All those in favor? That's carried. And we have 2 minutes until we move into our regular council meeting. Good evening, and thank everybody for coming out on such a blustery night. We really do appreciate the attendance. It's great to have everybody here. And welcome to our first meeting of 2019. And I'm going to open the meeting now. I'm going to ask you if you have a cell phone, to please see that it's either on silent or vibrate so it doesn't interfere with the proceedings. And I'm also going to let you know that public comments made during this meeting are audio and video recorded and shall form part of the record, which will be retained by our town's clerk's office. And we have a retention bylaw, and for more information about that bylaw, you can talk to the clerk's office and they'll inform you of what that's about. So we'll open with the open forum. Open forum gives the opportunity for members of the public to talk a few minutes about an item that is on tonight's agenda. And so we will start with Carl, I'm going to do this wrong, Kunij?
No, that's right. I just want to address the parking on my street. I get a lot of parents that park on I live on Swan Street, right across from Alcona Glen. A lot of the parents are parking in front of our street, like we have no parking put in front of our house, and we're getting our driveways are being blocked. They're coming around the corners. They're blocking the corners. We can't get out of our driveway. We can't go down the street. My girlfriend that's living with me, she leaves at 8:30. She gets stopped. She's had to get out of her car, knock on people's windows, get them to move their cars. I've even had people parking in my driveway. Like I said, we got no parking put up, and it's just not being obeyed. We don't see any bylaw out there, and whenever we're out there, we don't see bylaw. I call, I complain, I try to do whatever, and I don't see any results.
Thank you for that. So we'll be dealing with that on item H3. Councillor Asadi?
Thank you. Just for clarification for the other council members, because in a report, this resident lives on Swan Street. The item that he's referring to, speaking to tonight, is H3 on the traffic calming report for Alcona Glen, and it does reference Swan Street in the document.
Thank you very much. So when we get to H3, stay tuned, and I'm sure you'll hear some debate.
Okay.
Thank you.
Thank you.
Next item is Sheetal Rawal, I should know that, and she's going to speak to item D8, the Open for Business bylaw.
Thank you. Your Worship, Deputy Mayor, and Councillors, thank you for the opportunity to speak to Agenda Item D8, the staff report regarding the Open for Business bylaw. My name is Sheetal Rawal. I'm a resident of Cookstown, where I also practice law. The staff report raises what the authors call, quote, serious concerns with Schedule 10 of Bill 66, which would allow municipalities to pass open for business planning bylaws that could bypass important health and environmental protections, including those for Lake Simcoe and our drinking water. The report states at page 5 that it will, quote, will threaten the health of communities across the province, end quote. It also cites the significant pressure the town council will face to pass open for business bylaws and the democratic deficiencies in the process created by the bill, which include no public notice and no right of appeal for open for business bylaws. The staff report, however, concludes at page 6 that while flawed, Bill 66, as a matter of expedience, could provide opportunities to reach planning goals more easily. With all due respect, expedience or ease are not compelling objectives that justify placing the health and democracy of our community at risk. Yes, Bill 66 would make things easier in that it would remove a requirement to comply with the checkpoints that our society has developed to safeguard our health, environment, and democracy. And that's not a good reason. So to conclude, as I see it, the Council has two paths moving forward with this report. The first is to recognize Council's role in protecting the well-being of our community and ask for another staff report that gives due consideration to the threats to health, the environment, and public participation that this staff report that you'll be speaking to today has raised before providing comment to the province. It's also surprising that this report does not consider the impact of Bill 66 on Lake Simcoe, especially because we have a major tourism industry and brand built around the lake. Those questions should be examined more closely. And finally, the second and more appropriate path forward based on this report is for Council to pass a resolution that the town will not be using the open for business bylaw mechanism as currently proposed. This town is not in a position to remedy the flaws in Bill 66, regardless of any potential flexibility, to use a term used in the report. And I have examples in my submissions, which I'll give to you in written form. One example is that the council would not be able to create a right of appeal under the tribunal. So to conclude, Even if this council is able to act as good caretakers of the OFB bylaw power, there's nothing to stop the next council, who will face significant pressure to use it, as the report notes, from making decisions that are not necessarily in the public interest. There will be incentives to flood campaigns with donations and wine and dine the people who will sit in those seats after you. Let's not play this game. It puts our communities at risk. It asks us to bet the farm for no good reason. And I think the town of Innisfil should be leading the region with a principled approach that prioritizes the health of our communities, our natural heritage, like Simcoe, and our democratic rights. This is a Pandora's box. It's tempting, it's meant to tempt, but for our sake and for the sake of future generations, please don't open it. Thank you. And I have my written submissions. I'll pass.
Thank you. If you could hand those to the clerk, Ms. Rowell, thank you very much for that. Next is Claire Malcolmson, and it's on the same agenda item, D8.
Hello. Congratulations, Your Worship, Deputy Mayor, members of council. Nice to see you here again. My name is Claire Malcolmson. I'm the Executive Director of the Rescue Lake Simcoe Coalition. I could just say ditto to what Sheetal said, but I'll add a little more. I support what she's just said. So I am here to speak to item D8. So first of all, I just want to say overall, this open for business bylaw allowed in Bill 66 really kind of represents to me the Pandora's box of bad planning. I mean, I think a lot of the legislation that could be struck should this bill become law are things that we count on in our community and in our democracy to not run into a lot of problems that cost us in a number of ways down the road. I want to congratulate the staff who wrote the report, though, for, in particular, the following sentence: providing municipalities with the opportunity to completely disregard all of these provincial planning policies will threaten the health of communities across the province. Staff, two sentences actually. Staff are also concerned that zoning amendments will not be subject to public notice and consultation process. I agree with that statement. So my request would be that at your next meeting, you consider doing what happened this afternoon in Bradford and has already happened in Aurora, and something like it happened in Barrie. A number of other municipalities have passed a motion of council saying they will not use this bylaw provision. If that's not the way you go, my next preference, my second choice would be that at a minimum, that you do something similar that was referenced at the East Gwillimbury Council yesterday, that they'll put out a public statement saying that they will in fact use the public consultation mechanisms that we all rely on currently in our democracy for people to provide input on things that affect them. And at a minimum, that this motion that I would hope you would pass would include the consultation piece and certainly follow the Clean Water Act and the Lake Simcoe Protection Act and plan. And finally, in whatever time I have remaining, I just want to highlight the importance of Lake Simcoe. In addition to what Sheetal has just said, we have a phosphorus pollution problem here at Lake Simcoe. The Lake Simcoe Protection Plan is a bit like a roadmap to tackling that monster. We need to implement the Lake Simcoe Protection Plan, not sweep it aside. And I think that's probably enough. Thank you.
Thank you, Ms. Malcolmson. And next is Deborah McGrath, again on item D8.
Thank you, Your Worship, members of council. On Sunday, you received the Innisfil District Association's deputation regarding Bill 66. I hope you've had a chance to read it. It was well written by our board director, Ross Pittock. I'm not going to recount the contents of it, but I do want to reiterate what both Sheetal and Claire have warned us of. What is ahead? Innisfil is known for forward thinking. We're known for innovation and vision. Let's be forward thinkers. I'm going to recap our last paragraph in this correspondence. we ask that you make a resolution to declare that the town of Innisfil will not use Bill 66, open for business zoning bylaws, to prevent certain prescribed provisions, as Claire has mentioned, in the Clean Water Act, the Greenbelt Act, the Great Lakes Protection Act, the Lake Simcoe Protection Act, the Oak Ridges Moraine Conservation Act, the Resource Recovery and Circular Economy Act, and other provincial statutes. We want to ensure that all current bylaws apply to the above provisions. We also ask that there is always an opportunity for transparency, for dialogue, and for public consultation in every development application. We urge Council to think deeply and choose wisely. Thank you.
Thank you, Ms. McGrath. And that's everybody who signed up for the open forum tonight, so thank you very much for coming out and sharing your thoughts with us. Next is the approval of the agenda, and we have the agenda as printed with 2 walk-ons, and I know council's not fond of walk-ons, but we have 2 of them. One tonight under a bylaw appointment for our alternate member of the County of Simcoe, and another one is a staff report regarding KLM planners in regards with item DSR 00919. So I need a mover and a seconder for the agenda, and that's moved by Councillor Van Berkel, seconded by Councillor Nicol. All in favor of the agenda as amended? And that's carried. Next, I'd ask for disclosure of pecuniary interest. If there's any, I see nothing, but if something comes to you during the meeting, please just make us aware and the clerk will make note. Next is our presentations and petitions. And first, we welcome Ms. Donna Weiss from the Innisfil Historical Society to talk about Innisfil 2020 updates. Ms. Weiss, welcome.
Thank you. And good evening, everyone. Happy New Year, Your Worship, Council, staff, members of the public. It's great to have an opportunity like this to come and give you some insights into how we're progressing with the Innisfil Review 2020 Bicentennial Edition book. And it is a work in progress. You're probably quite aware that there were 3 preceding books before this. So one in 1951 when the town had a population of 3,500, and 2 following that in 1967 and 1984. So what we're trying to do with this one is catch up from the last one in 84. And as you can only well imagine, there's a lot to catch up on. So the real purpose of this book is to make known the fact that Innisfil will be turning 200 years of age in 2020. So I wonder what size of a birthday cake we'll have to make for the citizens of Innisfil now. You can be debating that. So 200 years, so in 1820, the first lots and concessions were laid out, and very soon after that, the first settlers came through the Big Bay Point area. This is a book a brochure we prepared in May of 2017, so it gives you the idea that we've been at this now for several years, working forward, acquiring stories, accumulating contacts, and really quite busy, quite successful. And the brochures have been the main contact point. Now, somewhere in front of you, councillors, or in a shelf, or you should have a little stack of them, and we'll touch very shortly on what you're going to be asked to do with those. Here's my team. You'll recognize some of those names as former town employees, and they play a very key role with us. So they are allowed to delve into the records of the town, read the minutes, and gather a lot of information for us. As well, we have a solid working relationship with the library. A young man from Nantyre contacted me and presented me with this design, and I thought that it was very appropriate, and we hope we can find a place for that slogan. The biggest section to date that we have is our older citizens of Innisfil. So to be in this section, you had to be 90 by 2020 or older than that, and we have quite a number who are in that category. Now, sad to say that Adolf von Grafen, who is there in that photo, died just about a year ago, but because we recognized that they were such a fragile group, we had done our best to meet with most of them. And Joan McLean from Cookstown, also deceased just before Christmas. And you may recognize Hank Abspel. He's alive and well, and he is very much an active member of the Innisfil Historical Society. Now, another section is local businesses, be they big or small, be they long-term or just current businesses. So who recognizes Louie's Pizza Place in Cookstown? If you drive by that way, you may just recognize, and there's Louie himself in the door, and I'm sure he's been deceased a number of years, so, but the Potoko family is still running that little shop. Formerly Innisfil Gardens, now Lakeside Retirement. It was refurbished in 1996, or no, I should say it was built in 96 and refurbished under the new management. There are currently 110 residents in Lakeside Retirement, and I found out that many of them are Innisfil residents. And I think that's a key point to the success of that business right now, that Innisfil residents, possibly the over 80 group, are finding a wonderful home right in our midst. That was, I should go back, that was Sherry Britnell with Lavender Floral. Now, she too has been in business for 12 years. Now has 8 employees. Like, these are the little success stories that are coming to us, and we're pleased to have those. Families, stories of families. You don't have to be a pioneer family. You can be a family that's moved in a number of years ago, and here's Grandma Vogan with her grandchildren. They're from the Guilford area. You might recognize this proud dad, Chris Simon, his small family. It's not small, it exceeds the national average now, so what progress have we made? Well, we've met 16 times, and I think when you get to 16 times, we'll talk. You know, you'll have been in it for 3 years, and so we're really gathering steam. We have conducted all these interviews with the older group in particular. We have currently 65 business stories completed. By no means are we done. We're just underway. We're rolling along. And we've made endless phone calls and contact queries. Now, some of you should look slightly guilty. You know I've been talking to you, and yes, there you are. There she is. You know you haven't just quite up to the measure yet, but I'm sure you will. Now, the challenges that we face, this is no surprise to you, that a small group of people have no way of contacting all corners of the town. So that's partly what I'm asking of you. How can you spread the word in your own ward? How can you connect with some businesses we may have overlooked, or some families that have been there long term? In particular, I know in the Alcona area, and I don't think any one person can do all this, but for example, I was doing a talk on immigration, and I was consulting with the secretaries at Alcona Glen, and they were advising me that there were 22 nationalities attending their school. So one of my committee's goals was, I wonder if we can get a story from every one of those nationalities. Well, I think we've only covered 4 so far, so you can see there's some challenges ahead for us. Now, technically, 2019 is our last full year. You have to think in terms of if the grand celebration for the 200 years is going to occur in the summer of 2020, then you back frame that. We have to have it to our printer 2 months ahead. We have to have it to our editor to have her do the finessing touches. 2 months ahead of that. You can see that 2020 is not too much time available to us, so we are full steam ahead. And maybe that's it. Or, what do you think?
Did you have more slides, Donna?
I think so.
Okay.
Is the big ask for you.
Oh, maybe that's why it got.
Yeah, that's why. Now I'm nervous. Here we are. So how can the council help? Thank you, Kim. Well, maybe. What do you think? Okay. Oh, okay, thank you. So clearly, we need you to spread the word, and that includes everyone you socialize with, eat dinner with, anything you do. Please, let them know about this project. Of course, I'm asking you to write your own stories. I have heard from different people, oh, nothing exciting's ever happened to me. Well, you know what? I don't buy that. I think you have something to tell us. Why did you come to Innisfil? When did you come? How are things going? What have you been up to? Please hand out those brochures. Be happy to answer any questions, should there be any. If there are any additional topics that you'd care for us to add, please consult with me. Now, here's a little tidbit. Did you know the 1951 review was handed out to every one of those 3,500 taxpayers free? Now, wouldn't you feel great if in 2020 you could do the same? So I leave that thought with you. Thank you very much for your attention.
Thank you very much, Donna. And I'm sure the treasurer is doing the calculations as we speak to see what that would, but we would budget for that. Questions or comments? Councillor Payne.
Thank you, Madam Chair, and thank you, Donna. That was a good thing. So anyway, as a resident of Sandy Cove Acres, and you know that there's a lot of old folks there, I will be asking them to put something in for you if they want to.
Yes.
We have a newsletter that goes out to all the residents, and I have a little corner like Carolyn's Town News or whatever. So I will put that in there, and even if they haven't been in Sandy Cove that long, they could have lived in Innisfil.
Absolutely.
So we can get the information from them. So I'll
Yes.
pass that on.
Yes, definitely. Thank you.
You're
Be great.
Deputy Mayor?
Thank you. Donna, you and I have chatted, so if you'd like to get more of these to me, I have an outlet to not dispose of them, disperse.
And you have a check mark next to your name. You know
Okay,
that,
great.
yeah.
I'll help you. Great, thanks.
Anyone else? Councillor Asadi.
Thank you. Donna, I just wanted to say thank you to you and your committee for all the dedication, hard work you've put in for making Innisfil's history such a good read. So thank you.
Thank you. And on that note, then I would ask for a mover and a seconder for the recommendation on the screen. Deputy Mayor Davidson and Councillor Fowler. All those in favor? That's carried unanimously. Thank you very much for your time, Donna. Next, we have Terry Chambers and Vanessa Hurley from the Muskoka District Health Unit, Simcoe Muskoka District Health Unit, with the Taking Action on Food Insecurity. Welcome, ladies.
Thank you. So congratulations to everyone, and here's to a good term. Mayor Dolan, members of council, staff, and the public here tonight. As Lynn said, my name is Terry Chambers. I'm a public health nurse. And with me tonight, I have Vanessa Hurley. Vanessa is a public health nutritionist. And we're colleagues on the Chronic Disease Prevention Program at the Simcoe Muskoka District Health Unit. And we're here as Christine Bushy, our manager, wasn't able to be here tonight. So the purpose of the delegation is to provide an overview of the issue of household food insecurity, discuss the implications for municipalities, and look at what municipalities, including the town of Innisfil, are already doing, and consider what other actions municipalities like Innisfil can take. Am I doing this? Oh, okay, we did move on, so thank you. So what is household food insecurity? It's described as insecure or inadequate access to food due to financial constraints. So in other words, people have no money for food. Their pockets are empty. And by the time an individual or family is experiencing food insecurity, you know, they've likely tried many things to cope. We heard of a story of a man when we were doing our research saying that he had to sell his $400 watch for $100 because he had lost his job. He didn't have enough money to pay for rent and food, so people are doing a lot of things to cope. And that's why household food insecurity is considered to be a better indicator of material deprivation than income alone. So to address household food insecurity, it requires income responses. And food insecurity is a big problem in Simcoe, Muskoka. It's not a very visible one. It affects about 1 in 8 households in Simcoe, Muskoka. That's about 12% of the population. And just think, this represents about 70,000 people, so that's the total population of the town of Innisfil and the town of Bradford West Gwillimbury combined. And so far, the main responses to food insecurity have been community-based and food-focused, things like food charity, food banks and soup kitchens, and they address urgent or emergency food needs. Community food programs like community gardens, good food boxes, school programs, and other programs that bring people together to cook and to learn food skills. Yet we know that despite all these efforts, there's been little change in the rate of household food insecurity over the past decade or more. Food insecurity is rooted in poverty. It takes more than food to solve food insecurity. Income-based solutions are needed. Food insecurity takes a toll on health. If we look here, it affects all ages, all stages of life. It affects people's physical, mental, and social health. And food insecure individuals, they feel isolated and alone, as they may be out with the means to meet for coffee at Tim's with friends, or to invite a friend over for coffee, dessert, or a meal. They might feel embarrassed because they don't have money to feed themselves or their families the way they would like to. And parents often go without food to ensure that their children have enough. Again, some of our lived experiences that we've talked with people, a parent, a single mom of 2 kids, shared that she had to eat potatoes for most of the winter just so her kids could eat food. Food insecurity impacts her health care and use and costs. The more food insecure a person is, the greater the use and demand on hospital, physician, emergency, and other healthcare services. And healthcare costs are higher. For example, someone living in Ontario who wasn't worried about food insecurity, their annual healthcare costs would be about $1,600. If we look at a person who's extremely food insecure, their annual healthcare costs would be closer to $4,000. So that's about 121% higher. And further, food insecurity is a strong predictor of whether someone will become a high-cost user of healthcare within the next 5 years. So if we look at reducing food insecurity, it will benefit municipal governments and our communities. It can reduce demand on a wide range of local health services, including mental health services. And as you noticed earlier, food insecurity has an impact on people's mental health and well-being. And if we do this, we can benefit the municipal bottom line by making more effective use of funding that supports these services in the community. And community well-being is very important to municipalities. Reducing food insecurity supports the creation of more equitable communities, which benefits everyone's well-being. And we acknowledge that the town of Innisfil, you work really hard to increase resident engagement. But just think about someone who's feeling isolated or powerless, as in the case of someone that's experiencing food insecurity every day. Their main concerns are, am I going to be able to eat? How am I going to eat? Where am I going to go? So it's difficult for them to feel connected to their community and to participate in civic activities, including community consultations, a lot of which Innisfil has. So as a result, there's a great risk that the voices of these people who are food insecure is going to be missed when municipalities are seeking community input on their policies and planning issues. So when a person's no longer focusing on finding money for food or where's my next meal going to be, they can turn their attention to longer-term goals. They can start thinking about learning or personal development. They can then maybe go into education or get some education training. And this helps the municipalities because they enter the labor market and maybe even become an entrepreneur. So more money for food and other basics then means more money that makes it back into the local economy to support local business. So it is a challenge. It takes more than food then to solve hunger. Poverty is the root cause of food insecurity. And it's income solutions that are needed for any kind of sustainable long-term impact. So as I mentioned earlier, yes, the food charity, food banks, food boxes, community food programs, they do have many benefits. Things like helping people to reduce social isolation. They get out, they meet other people, that boosts their feelings of community and belonging. It does help to increase their fruit and vegetable intake. But these are good for everyone at any income level. Yet all these good things that we're doing, if we look at it, they don't have an impact on food insecurity because they do not increase income. So municipalities do have an important role to play in addressing food insecurity. Municipalities have influence over a number of policies that can help reduce food insecurity by increasing the disposable income available for food and other necessities. And many municipalities are already taking actions that help put more money for food in people's pockets. And some examples of Innisfil, you've endorsed an Economic Development Community Improvement Plan, or CIP, and that allows the town to provide financial incentives to new and expanding businesses so we can keep people in Innisfil. And you've also implemented the ride sharing transit partnership with Uber, the first in Canada. And that brings reliable, affordable transit to residents, and it can help them improve their access to education, maybe going to a job interview, training, and other employment opportunities. So you are doing some good things already. We just ask that you look at what you're doing and consider building on that. Another piece is considering an advocacy role. And an advocacy role potentially to the provincial government. And why advocate? We know that Premier Ford has been making a lot of changes right now. We know that social assistance rates are not enough. 2/3 or 64% of all households receiving social assistance are food insecure, and that's an Ontario stat. And just because you have a job or two, that's no guarantee that you have enough money for food, because a lot of the jobs are precarious. Almost 60% of food insecure individuals and families rely on wages and salaries as their source of income. These are the working poor. So we recognize that municipalities are the lowest funded level of government and that there's many demands on your budgets. And we respectfully ask that you continue to consider income supporting actions such as the ones outlined here. And we're encouraging municipalities to monitor poverty annually and then use this information to inform your policy decisions that can improve incomes for people struggling with food insecurity. We'd be happy to work with you to provide you with more information for council members, committees of council, staff, with respect to household food insecurity, and to explore possibilities on building on the great work that you're doing already. So we thank you for this opportunity, and we look forward to working with you. I believe my time's almost up, but I really would like to show a video. This was a video that was done by a grade 5 student who has quite an interest in food insecurity. So hearing from a young voice, I think is very effective.
Hello, my name is Noah Holland. My name is Noah Holland, and I'm a grade 5 student where I pick an issue I'm passionate about and try to help change. I'm passionate about the issue of food insecurity, which is inadequate or insecure access to food due to not having enough. I've been very fortunate to have always had enough food in my house, and I couldn't imagine not having enough. There are people around us who have to make the decision of, should I not eat so my kid can? 1 in 8 households in Simcoe Muskoka is food insecure. As many as 1,500 kids in just Simcoe Muskoka go to school or bed hungry, often or every day. Adults living in food insecure households account for more than 1/3 of all hospitalizations due to mental health issues. Think about all the kids who have problems with food insecurity and all the potential that was lost because these kids couldn't focus in class or couldn't try their hardest in sports, all because they didn't have enough food to eat, and they were worrying about the rest of their families because they didn't have enough food to eat either. These families need more money in their pockets. They need better, higher paying jobs, and they need affordable housing. Please continue to make these things a priority when you are making decisions for our communities and our families. Thank you.
Thank you, Noah. We're working with Noah again this year. He wants to continue to work on this initiative, so we're working with him again. So thank you very much.
Thank you very much, Terry, for being here tonight. I appreciate that. And if you could pass along to Christine. I know she came here to make this presentation one other night, and we had a rather robust public meeting that night, and she was unable to make her presentation. So thank you for coming back.
Thank you.
And I'll open for questions of council. Deputy Mayor.
Thank you, Your Worship. Your Worship and I are involved with the County Council and working with seniors. And just to let the general public know that in the county system of seniors homes that we have, that with the provincial allotment for food per day, we actually subsidize the food allotment, we the taxpayers of Simcoe County, because what we receive from the province per senior is around $7, I think it was increased to 75 cents a day. And we have to feed them 3 meals and 3 snacks a day on that. So trust me, they're not getting fresh fruit, they're not getting bananas, they're not getting anything. So this system is right from the top down. So it's not just in homes, it's our seniors that are in homes as well.
Yes, yeah, it affects all ages, people.
Thank you.
Seeing no other questions, thank you again, and ask for a mover and a seconder for the recommendation as is on the screen, which directs staff to work with Simcoe Muskoka District Health Unit to explore reducing household food insecurity in the town of Innisfil. And it's moved by Deputy Mayor Davidson and seconded by Councillor Ices. All in favor? Opposed? That's carried. Thank you one more time.
I look forward to working with you.
Thank
Thanks.
you. And next, we welcome Mr. Jim Roberts. Yes, absolutely. We can accommodate that. Mr. Roberts, have a seat.
Thank you.
I would like to thank Ms. Mayor and the council for letting us speak tonight. I guess my name is Jim Roberts, and I'm representing Mark Davis, who lives at 1405 Guilford Road, or I'm helping Mark. I hope council has been able to review the material we emailed you guys. There was quite a bit of material there. I hope you guys got through it. I'm going to try to not repeat myself with this tonight because basically you guys have it all there. This is our 4th appearance in front of council. We have had numerous meetings and phone calls with town staff. We have spent hundreds of hours trying to resolve this issue. In our opinion, the developer ignored bylaw 050-13 as amended by bylaw 045-14. They also ignored engineering design standards and specifications for grading and drainage in the town of Innisfil. Builder also ignored town bylaws, in quotations, whereas the development is prohibited from allowing water to drain from one property to another, end of quotations, and Ontario Building Code, which states, quotations, that regrading of soil of land shall not adversely affect neighboring property, end of quotation. There was no attempt to make the grade of Mark's property work with the finished grade of the subdivision. We have a picture. Just one picture. I guess it's going to be two pictures. Okay, there's the first picture there. This is the second picture. The first one actually was taken off Google Maps in 2015. The material behind there is actually, the fill has already been brought in, the initial fill. This started in 2013, but this is a picture of Mark's house. I guess you can see where everything kind of falls away from Mark's house. In fact, before 2013, all of the water, the storm water on Mark's property drained away from his house into the open field. The second picture here, this now shows Mark's backyard. You can see retaining walls. There was as much as 5 feet of fill added there. There's now a swale that surrounds his property. He's kind of stuck in a hole with a moat around it. Anyway, drainage issues have not been resolved, and there has been 5 years of chronic flooding and mudslides on Mark's property. The wall and swale that now surrounds Mark's property is not going to work. There is still going to be chronic flooding. There will be continued acrimony with Mark's neighbors about maintenance of the swale, drains, wall, and fence. In our opinion, the town is setting a precedent where any neighbor can elevate the grade level of their property and change drainage patterns. If it can happen to Mark, it can happen to anyone. After the meeting we attended on September the 5th, 2018, with 3 members of town staff and 2 members from Christina Homes, we realized that no one really cared about Mark, his property, or his concerns. One of the many examples is when we pointed out damage caused by a 2017 mudslide from the lot to the south of Mark's lot. A town staff member told Mark that he should have made a claim on his own insurance policy. Paid the $500 deductible and sucked it up for something that happened to him out of his control. Another example is when it was agreed that Christina Homes would reimburse Mark for the damages done to his shop. He later received a letter saying in order to get the $1,000, he would have to sign a release saying that he would bring, in quotations, no future claims against Christina Homes. Also, with the hard surfacing of the subdivision property, the ground no longer infiltrates stormwater, and we have a flooding issue on Guilford Road. There was a picture in the material I showed you guys of the flooding that's occurring now. From an article in the Innisfil Journal, December the 13th, 2018, Deputy Mayor Dan Davidson is quoted as saying, "Innisfil must address how we grow in a way that protects all residents." End of quotations. We are hoping that the new council will look at not only sustainable new growth, but make sure it does not adversely affect the people that currently live in Innisfil. Mark is looking for some kind of closure on the devastating impact the building of this subdivision has had on his life, the value of his property, and his well-being. Thank you very much.
Thank you very much, Mr. Roberts. Questions, comments? Council, Deputy Mayor Davidson.
Thank you, Worship. I've just had a chance to read up on this when we received the document. I've seen the pictures. I agree with you. I don't know how this happened. If this was my property, I'd be upset. Just earlier tonight, we were presented with the update on the Drainage Act. I don't know if you have this book or it's available to you. I'd make it available for you to read to help out your friend. And it sort of contains any issues that would do with drainage in the municipality. So you might want to take a look at this. I can hand it to you, no problem. I'm hoping staff can work with you on this matter as soon as possible and try to rectify it. I don't think we can buy the property, but let's see what we can do to work through to a solution, because I don't believe development should get away with destroying somebody's property. Thank you.
Councillor Nicol?
Thank you, Worship. I actually had a whole thing here, a page and a half that I was going to go through, but I'll just go through quickly. So I was trying to think how many times Jim and Mark had raised the drainage issues on this development. My notes, actually, I printed them all off, so they go back to March 19th, 2015 in the public meetings. I took some time this weekend trying to pull all these old notes together, and I was coming guns a-blazing tonight, believing that staff and the developer were not working to rectify this flooding issue or working with Mr. Davis and Mr. Roberts. In reading the info from Jim, and I was angered and wondered if, we had another Copeland Crescent or Victoria Street and another 10-year fight coming up. So, but looking at the town logs that I got today from the staff, it appears that they have been in contact at least a few times every month, and I just added it up. So it's 27 times since May till January that they've been in contact. The breakwall itself has been rebuilt, I understand, 3 times now. The flooding pictures, obviously, from July are impressive and disappointing completely, obviously, but looking at the street, there was quite an event that happened there. The one thing that stood out with me was that I read at the September 5th meeting on item 3 that everybody had agreed to review in the spring before considering closing any of the grading certificates. And I wonder if in the spring the flooding does continue, is there a mechanism to bring this lot up to the surrounding grades through either a purchase at fair market value or some other solution through town staff and the developer to finally bring some closure to this?
Mr. McKenzie?
Through you, Your Worship, to Councillor Nicol. We're happy to meet with Mr. Roberts and discuss. We did send him a letter yesterday addressing all of his concerns here. And I think to avoid going through every single comment here in the open forum, we can meet outside these chambers and go through our responses to him yesterday and try to work with a solution. But as you mentioned, we did agree to not even go here until the spring. We were all in agreement to meet again in the spring and review the flooding. The pictures from July were prior to the sod being placed, and I am not aware of any flooding that has taken place since the sod has been placed. We certainly haven't heard from Mr. Roberts or Mr. Davis. We were anticipating going out in the spring. But my recommendation would be to wait till the spring, take a look at the grading, and then see what happens when the snow melts and the spring thaws here. That's what was agreed to.
That was agreed to before we, excuse me, it's okay if I talk?
Go ahead, Mr. Roberts.
That was agreed to before we received that letter from Christina Holmes, wanting us to sign off. And I'm sorry, like Mark can never sign off here, as far as I'm concerned, on anything, because there's always going to be something happen there. This is not a solution for a situation like this. Mark should have either been bought out at the start of the whole thing, fair market value. You can't build a subdivision around a house if you're going to change the levels like this. Or else, there should have been provisions made to raise the back of Mark's lot to the same height as the subdivision. Put a new septic bed in for him, replace his shop. Or else, they could buy Mark out for fair market value. They could build another subdivision house, and the developer would not be out that much money, because those new houses, I guess, apparently are going for over $1 million. So, there's solutions here that are not going to cost anybody a lot of money. But the thing for Mark is, this is a never-ending.
Thank you, Mr. Roberts. Mr. Rayner.
Thank you, Your Worship, and I think we'd all be lucky to have Mr. Roberts as a friend. This Mark person is a pretty lucky guy to have an advocate like this. I think at this point, rather than, you have a very busy agenda, and you don't have anything from staff, as far as I understand, in terms of a briefing memo on this file, perhaps you could direct it back to us, and we can investigate and report back to you in due course.
Thank you. We did get a late email from Mr. McKenzie that shows the chronological, and it is a hefty file. So yes, I would ask that if with council's concurrence, that we refer back to staff to just have discussions with Mr. Davis and Mr. Roberts. Councillor Seti.
I just wonder if, Mayor Dolan, if in that report there could be an explanation from engineering as to why there is the need to increase in elevation between flat level yards to a 3.5-foot difference, because it does happen in other areas in the town. I know Councillor Nicol and I have discussed a similar one. So if we could have that in the report, that would help us as council to understand that.
Thank you, Councillor Seti. So I wasn't actually asking for a report back. This recommendation was asking that the delegation be referred to staff. However, we could ask Mr. McKenzie to, and I know we're going to have, as a council, have more 101s, and one of them would be planning, which would do site control and grading and so on and so forth. But Mr. McKenzie's writing, so I'm sure he'll be able to answer that question for you. Is there any other questions or comments? Okay, thank you. Hopefully, we can get this resolved in a matter that will satisfy everyone.
Thank you very much.
All in favor? There we go. Carried. A mover and a seconder for that recommendation first, I'm sorry. And it's moved by Councillor Payne and Councillor Van Berkel. Now all in favor. That's carried. Thank you, everyone. So now we're going to move into our agenda and ask that if there's any county council, I guess there's not a lot of associations yet, because as a new council, each councillor is just getting to the point where they're getting to be appointed to their different associations and conservation authorities, but this will be the opportunity and the agenda once you're on a committee to talk about any updates there is in that committee. I will take the opportunity to speak briefly about the county council. County council met, what's today? Yesterday, and the new council had a full day meeting discussing the budget. And we went through a number of different items. It is a $500 million budget, taking care of social services, paramedics, Ontario Works, the health unit, solid waste management. It's a big budget. There's about $38 million worth of capital projects being done, a lot of them in Innisfil this year. We're getting our fair share of capital projects work being done here, and it looks like we're leading towards about a 2% increase in the county levy, and what we're also going to be discussing shortly is adding a couple of yard waste pickups in the summer for our residents, but you'll hear more of that to come. But that's the county council update, unless you had anything, Deputy. Okay, great. So next is item 8, and item 8 is our consent list, and I was told before that we rushed through this too quickly and many people didn't understand the concept of what we were doing. So I will just take a few minutes. So council has had for a week their agenda and all of the background information that goes with it, and had the opportunity to read it and also talk to staff on items and get their questions answered. So now what we do is we go through all of those reports. Any reports that the recommendation that's listed in the agenda is something that council wants to not debate, that they're happy with that, like approval of minutes, that sort of thing, we will just confirm at the end of this list. Any items that council want to ask questions or debate further, we will refer to committee of the whole, and in the committee of the whole have that opportunity for a more fulsome discussion on those items. So I will go through this list right now, and we'll see which ones get referred to committee. So the first, item A1, is the adoption of the special council meetings of our very first meeting on December the 12th. Councillor Fowler? No, you good? Okay. The next item, A2, the regular council meeting minutes dated December the 12th. The next item, various reports of committee. So the Innisfil Community Grant Committee report on November 27th. Standard requests, there was none received. Our staff reports, the first one was the parking law bylaw amendment for Jans and Anna Maria. Councillor Sadi.
Yes, Mayor Dolan, I do not want to refer it. I just wonder if I could ask one clarification question on this.
Certainly.
Okay, so this would be to Carolina or Rhodes. Just a question, because I'm certainly in support of this staff report and the request by Nantar School. Just concerned with future development, how if we put these in place now, there's all homes that are have future planning to have their driveways coming all out on Jans Boulevard and Anna Maria. Would this be readdressed again at that time?
I can't see if Jessica's there. Is she?
Through your worship to Councillor Orsatti. Certainly, as with any bylaw, it can definitely be readdressed when we need to. However, with this particular restriction, although the current report aims it as sort of a means to an end to help prevent problems at the school, we do have other ongoing plans in the same location. For example, in our Trails Master Plan, we've got future bicycle lanes through the area. And so this was planned to also accommodate those uses in the future as well.
Thank you.
Councillor Nicol?
Thank you, Worship. I don't need to refer this either, just a comment. I don't have an issue at all with the recommendation. I just wanted to maybe note or emphasize the growing drug problem that needs to really be addressed. I thought I was aware of what was going on, but I'm stunned that there's 20 police calls in just the first 15 days of the school year this year. So I think we have a growing problem we need to address, and it may come up later in today's discussion as well, too. So,
Thank you. Next item is D2, the Municipal Election Accessibility Report. This item is due on January the 21st, so we need to pass this tonight. Okay. Next item is part lock exemption bylaw for Alcona Downs. Okay. D4, the terms of reference for all town committees. Councillor Payne.
I'd just like to defer that, please.
Refer to committee?
Yes, please.
Thank you. The next item, D5, staff report live streaming of council meetings. I just want to say that you'll be able to sit in the comfort of your own home in your PJs and watch our exciting debate starting next council meeting. And they'll be up on YouTube for 1 year. Before being taken down. So lots of opportunity. Yes, we're going to have makeup artists, I'm sure, come in and yes. So it would be nice to, it's just part of our work to try to further engage residents. So we're happy to see this come forward. So thanks for staff, and I will also say for anybody who is watching the first little while, be patient if, you know, this mics aren't working or the screen doesn't work right, and just maybe give us your feedback on what we can do to improve. Thank you. Next item is D6, the cannabis retail store, referred by Councillor Rob Nicol.
Thank you.
The D7, the Rizzardo Health and Wellness Center canopy, referred by Councillor Carolyn Payne. Next is the open for business proposed, Bill 66, referred by Councillor Rob Nicol. Next is 2 Center Street, the heritage alteration permit. Next is the Alcona visualization. I had just one comment to make on that one, and I think it's a great idea. I just want to point out, I did get several comments this Christmas that there's no Christmas lights in Alcona. I have been encouraging local groups to take on the project, just like they have in other of our downtown areas, and suggested that they also might want to apply to the Inspiring Innisfil Grant Fund in order to maybe help with that, but trying to just get the word out there. If there's any people who would like to maybe take on a project like that, it might be something, a good time to start in order to get it finished for next year. Hint, hint. Next is the staff report for the condominium exception for lands, Block 148. Okay, bylaws. So dedicate and assume certain lands to the town's road system, McNeil and Wilson Street. Good. Next is the amend the zoning bylaw. Remove the hold on El Sami. Good. Appointment of acting mayor, Councillor Rob Nicol. Deputy Mayor? Next would be correspondence for action. There's none. Items G, which is our correspondence list. G1, memo regarding the Stroud Innisfil Community Center. Just a comment that there is a date for that, for community engagement, and I will find out when it is. There it is. Sorry, the next one, if you could just scroll down, Patty, one. The next, no, all the way to the next correspondence. It talks in there. Keep going. There we go. It talks a little bit later about the date that I wanted to highlight to people. A little bit further. There we go. January 24th at the Stroud Community Center from 6 to 8 p.m. We're going to have an engagement session on the Stroud Innisfil Community Center and Banquet Hall. Thank you for that. All right, next item, letter from the Ministry of Municipal Affairs and Housing, re-municipal reporting burden. Good news, that one for sure. G3, minutes of the Innisfil Public Library Board. G4, FCM looking for nominations for their board of directors. G5, the health unit and their guide on legalization of cannabis. And that's it. Next, supplementary issues. The staff report regarding a second dwelling on 2 Summers. Councillor Nicol.
I don't need to refer this either, just a comment. I just think that this really showcases the continuous changes in the attitude and the direction that the town is working actually for the residents and not against them. For a resident to actually go through the official process is admirable, as it was noted in here that likely could have been easily absorbed and undetected with a family of 4 or circumvented some other way for that matter. I have no issue, and this is a compassionate solution for our residents. So,
Thank you, Councillor Nicol, and I would concur, and thank you for staff for making this happen. Next item, red light camera. I'm actually going to ask that that item be deferred until our next council meeting. Do I need a motion? Or I should get someone else to give a motion? Or refer it and then get a motion? Okay, refer that one to Committee of the Whole, please. Signal and pedestrian access improvements, Alcona Glen Elementary School. Councillor Sadi wants to refer, I mean. Next is supplementary items, the appointment of an alternate member of County of Simcoe Council bylaw. This is an item to pass a bylaw to allow Councillor Orsatti to attend and vote at Simcoe County Council whenever either the Deputy Mayor or myself are unable to attend. Item 8.1 is now our consent list. That agrees with my list. So can I have a mover and a seconder? Sorry, Councillor Deputy Mayor Davidson and Councillor Sadi. All those in favor? That's carried. And recommendation to resolve into Committee of the Whole, moved by Councillor Payne, seconded by Councillor Waters. All in favor? That's carried. So now we need the staff report. This one was referred by Councillor Nicol, who was, oh no, Councillor Payne. Councillor Payne, you referred this one?
Yes, I did. Indeed, I did. I would just like to...
Need a mover in a second.
Oh, before I do it?
Yeah.
Okay.
Moved by you, and you need a second.
Moved by myself and seconded by...
Councillor Waters?
Councillor Alex. Councillor Waters, yes, Alex Waters. Thank you. We have to get to know each other still. Okay. The question I have is regarding the minutes or the terms of reference for all the committees that on the year of the elections, all the committees end in June and they start again in the following new year. Is that correct?
Through your worship to Councillor Payne, yes, that is correct. Many municipalities have that provision in their terms of reference for their advisory committees. There is also provision, though, for special meetings to be held in the event that there is business that the committee needs to consider.
Okay, so so if something comes up in one of our meetings that we have to get together, we can just...
That is correct. It is so that the nature of the agenda for any committee meetings after June would be specific business items only.
Okay, so would we have to contact clerks to do that?
That would be correct. You could contact the council representative, would liaise with the staff representative and contact clerks to advise on the item that would require consideration, and we would poll council or committee members for a special meeting for that item only.
Okay, because I know there was question that they would like to continue on until September, but I understand how hectic it is for the staff during the municipal election time. So as long as we would be allowed to, if necessary, have another meeting, I think that would be
absolutely, we could accommodate that.
Okay, thank you.
Any other questions regarding the terms of reference for all town committees? And please know, like, once you start, the committee gets together and you start to, and if you encounter problems with the terms of reference, you can always come back and ask for council to revisit that. All in favor? That's carried. Next item is D6, and that was Councillor Rob Nicol.
Thank you, Worship. I actually can't move this motion. I did refer it, but I do have a revised motion that I'd like to introduce afterwards. But just wanted to put this out for healthy debate first, if possible.
Is there someone who wanted to move the recommendation by council? This is the staff recommendation for the cannabis retail stores. Moved by Councillor, are you moving, Councillor Fowler? Seconded by Councillor Payne. Okay, so the discussion now is on the motion that's on the floor, or on the staff report that you read. Questions or comments on that? Councillor Nicol.
Thank you, Worship. I do have quite a few questions I did send to staff already, but I just wanted to kind of go through point by point if it was possible. Obviously, this is a big decision for us and could have implications for quite some time to come. So to staff, can you tell me exactly what the benefit would be to the town of Innisfil and most of its residents if we were to opt in early now rather than waiting until the second round? You know, is the initial $15 million, out of that, how much could Innisfil reasonably expect if we opt in before the January 22nd date?
Mr. Pendakainen?
Through you, Your Worship, to Councillor Nicol. In terms of the funding, so in terms of the funding that would be expected from this is that, so if opting in, there's a first payment of $20,000 that the AMO has already said that the town would be receiving. Minister of Finance has indicated that. So there's a second payment that if the town opts out, they'd only be receiving $5,000 for that second payment. And opting in, it's difficult to estimate how much that second payment would be because it depends on the total number of municipalities that have opted in or opted out, but it would be at least that same $20,000 amount. So it's a minimum of $15,000 that would be lost in that second payment. And then if the town opts in, it's also eligible for the $10 million that the province has reserved for what they've determined to be unforeseen consequences. And also if the town opts in by January 22nd, there's over the next 2 years, if the Ontario's total tax revenue exceeds over $100 million, that municipalities that have opted in would be able to be eligible for that. So it's difficult to pin down exactly how much the town will be receiving, but the province, in a letter to the AMO from the Minister of Finance, has identified that funding that's available.
If you'll indulge me, I do have a couple of questions, and if somebody else needs to jump in. So again, looking around $20 million or $20,000 out of that $15 million, if we opt in ideally tonight. With that, I did look at a report from the York Regional Police, and I'm just wondering if South Simcoe Police anticipates similar additional costs as York did. They were estimating about 2% of their budget would go towards cannabis implementation, as well as screening devices. Their budget, the South Simcoe Police budget right now, based on 2%, that would be about $500,000 a year between Bradford and Innisfil. So I don't know that the $20,000 or $25,000 really going to offset that. I'm just wondering if there's has been any correspondence from South Simcoe other than just looking at their police budget, where they're looking at $60,000 over the next couple of years just for screening devices alone.
I'm going to use executive privilege and invite the chief to come forward and answer any questions that you might have, or were you prepared to answer that? I'm sorry to take you off guard there.
No, thank you. Through you, Mayor Dolan. That's why I'm here tonight. I anticipate there might be some questions with respect to our readiness for this. I have been working with staff, and again, we've had staff meeting with them and working towards this recommendation. We do have, and I don't know the exact amount, but we do have money in our capital budget present time for the purchase of devices. Our hope is that somewhere down the road there will be some funding from the government, provincial or federal, to offset the cost of those devices. But at the present time, that will fall to the taxpayer.
Thank you, Chief. Yeah, I actually looked at the 2019 budget we just received a couple of weeks ago, and over the next, I think, few years, there was $12,000 per year every year for the next couple of years. So again, if we were to get $20,000 or $25,000 or $30,000, clearly this would not even cover the cost of just the screening devices themselves, not even the training. So if I can continue on, if that's all right. Obviously, according to both the staff report and the AGCO facts, we would virtually have no control over the locations. The only stipulation I saw was 150 meters from any schools or community areas. With that, there were only 5 locations that were going to be somewhere between Barrie and Ottawa. We understand already, or I understand through the grapevine, that Innisfil was not chosen already, so we're not actually going to get one, even if we do opt in tonight. My concern is, without any town controls and looking at spots that are just 150 meters beyond from a school, what would stop any location from sprouting up in, say, the Sleeping Lion Mall in the middle of that community, the new plaza that's being built on Webster at IBR, just up from Alcona Glen, Clarny Beach Road, where the sales office is right now at the 20th, just next to Clarny Beach School. The proposed development of the Kimros property, which is just a shortcut to the Sunnybrae, or even what we saw tonight, Louis Place, just down from Cookstown Central. All those are at least just 150 or 160 meters from the community areas in the school. So I just wonder if we were to pass this, we would lose full control. Obviously, we opt in, we can never opt back out, but we wouldn't have any control over those sites. Is that correct?
Through you, through you, Deputy Mayor, sorry, through you, Mayor, to address, yes, thank you. The Planning Act and the zoning bylaw cannot be enforced with respect to the locations. However, the AGCO has mentioned to staff and noted on their AGCO website that there's a 15-day window for comments for potential private locations of cannabis stores. Within that 15 days allows the public and staff to comment on if that location for the store is in line with town policies as well as the town's bylaw. Typically those spaces would be located on retail zoned lands as outlined in the staff report. So as long as they are meeting the criteria outlined by the AGCO, staff's recommendation for those locations would be based on our place official plan and the zoning bylaw, as well as public comment.
I have 2 left, and I'm completely done. So clearly, for me, this is not about fighting the new cannabis law. It's here. It's in place. My question is, until we revise our smoking bylaw, how can I smoke a joint where I can't legally drink a beer in this town? How can we enact? How can we opt in before we actually get our actually smoking bylaw in place properly?
Through you, Mayor, to address Councillor Nichols' concerns about where you could possibly smoke. That is regulated by the provincial smoking laws, as well as the town's municipal smoking laws, which we are looking to amend in the near future. Currently, smoking of cannabis in Innisfil is legal anywhere that would permit it outside the provincial or municipal bylaws. But we are looking to further restrict that based on the report that's coming hopefully in the near future to amend that smoking bylaw.
Thank you, Your Worship. My last question. To me, obviously, the financial implications are not great enough, and rather than scrambling in to opt in right away, I wonder if it would not be responsible of this council to opt out now until we can observe the unintended consequences, as well as giving us a chance to update our smoking bylaws. Therefore, I do have a revised motion. I'll wait until other comments come out, though, and see if I can bring that forward. Thank you.
Councillor Ices.
I would concur with Councillor Nichols' concerns, and I didn't review this this issue on a financial matter in that way, but I thought more of it as a social concern. We are taking something that causes addictions that was formerly illegal and making it legal, and in a few short months we're asked to decide whether we have all of the answers to all of our questions as to where these stores will be allowed to be in place, and with the social consequences of some of that, there's concern over cannabis being a gateway drug to the harder drugs, and we know that those drugs are unfortunately present in our community. Kudos to the South Simcoe Police for stopping some of that in the last ride program, but I just think as a resident of Innisfil, we want to have more of our questions answered before we rush into something, and especially when the financial benefits are so small. I think if you ask families who are dealing with addictions if what the cost of helping their family members get off of it, just in their family alone, they'll be spending more than that $20,000 that the town will be getting to deal with this. So I am hoping we can step aside until we have some more answers, and in the meantime, it is legal and there's still access to it online. So that's my feelings on this. I also wanted to ask, for the benefit of our community, if we could make this a recorded vote.
Thank you. I will do that, and I've got a few names, but I'm going to take an opportunity to jump in here just for a minute, because I want, this is a big debate, and I will tell you that we did tell the ministers, Minister Mulroney and Minister Fedeli, that it was unfair to ask a brand new council to deal with such a heady decision, but they were convinced they needed this decision by January 22nd, so we are required to make this decision. As we're making this decision, though, I would hope that we could just focus on the retail portion of it. The decision whether or not we think cannabis should have been legalized was made way above our pay grade. That ship has sailed. Whether you like it, whether you don't like it, whether you inhaled as a teenager, none of that matters. What matters tonight is whether or not we will allow a retail opt-out of having retail in our community. The reason I'm saying this is because I was at County Council one day when we had to decide how we were going to deal with assisted dying in our long-term care homes. Now, the debate went on for a day about whether or not you were morally agreed with assisted dying or whether you didn't, and what the Bible says. And that's all well and good, but that decision was made by somebody else. The only decision we had to make at the county that day was how we were going to deal with that particular policy in our long-term care homes. So that being said, just a couple of things. So the $40 million that is available throughout Ontario is for the first $100 million over the first 2 years. And over and above, so if the province makes over $100 million, in the excise tax, then it's split 50-50 between municipalities and the province. So the $20,000 figure, I don't know, and as Mr. Pentikainen says, that amount of money has to do with how many, if 50% of Ontario's municipalities opt out, then the pot for those who sorry, no pun intended, the amount of money for those who opt in becomes larger. And then the other point that I wanted to make is nobody with a municipality our size is going to get be chosen in the first round. It has to be municipalities over 50,000, and there's going to be 4 all the way from Ottawa to us. So just wanted to add that to it, and then I'll add some more later. But I won't hog the mic. I'll go to Councillor Waters.
Thank you, Mayor. I agree with you fully that that ship has sailed, and so the decision's been made for us. And I think originally I was willing to kick the can down the road until staff did a survey. And they asked the people of Innisfil what they thought of allowing retail outlets in Innisfil. And I think it was 70% agreed that they wanted that. I think it was even over 50% for the older population. So I'd say the town people have spoken, but I wouldn't mind staff maybe just to clarify in terms of how that survey was done. It doesn't reflect multiple votes by single people trying to weigh the decision one way or the other. So if we could just get some clarification on that, and I'll have a point to be made after that's made. Thank you.
Through you to Councillor Waters. So that was an online survey that had over 800 responses, so which is probably the most from any online survey for any topic. So it was through the town's Get Involved Innisfil platform. So it's different than a SurveyMonkey that's commonly used as well, where the same person could be doing multiple entries. So this through the Get Involved Innisfil platform. It requires you to sign up with an email. So that puts a check in place that it's typically just one person doing one entry on the, so we're pretty confident that they're very legitimate responses, and that over 800 responses wasn't swayed in any way.
Thank you. So 70% of the people in Innisfil said they want to have retail outlets. That's correct then?
Yes, that's correct.
Then I'd like to just remind council that we were voted in on 30%. And so I think that says a lot that people in Innisfil have spoken. They've told us what they want. And as council, we should be carrying out their wishes. Thank you.
Councillor Sadi.
Thank you, Mayor Dolan. I agree with your comments. I think sometimes on these issues, we have to have a paradigm shift in how we look at it. As you said, it's not about whether we believe in the product, whether we use the product or agree with it. It's legislated. It's here. So the option is the retail stores. I had a resident who, we talk about addictions, gambling, alcohol, smoking itself, and the health causes, the impacts to that. I had a resident who challenged me before on why we allowed the OLG to Innisfil, because they had a gambling addiction and they lost their house. So we allow, you have to look at how you look at the retail, the service. So I look at it as retail, jobs, taxes, opportunity. Yes, it is a caveat of a carrot that's dangled in front of us. Don't like the way it's been a change in a government, but it is here. So we have a choice of looking at, if it is not in retail stores in our community, there is more likelihood that there is going to be backyard sales to those who do not want to go to Barrie that has approved it, and the town of Bradford that has approved retail stores. So I see more of the situation happening that's happening for recommendations for parking outside Nantyre School. So the thing that I was interested in, and I had we've had so many emails. I watched the Barrie Council. I downloaded their staff report. I was so impressed with it. It was very detailed before they approved all the things that they wanted to put in place. Mr. Scarrett, I had sent you an email. You had responded. I haven't had time to read that. And my question is that in light of what you've said, Mayor Dolan, about it could be a year before we even get a license for a retail store. In that time, we would be able to see how other municipalities, it is working. Do we have to have all of our policies set in place other than the smoking bylaw, which would be in no public places? So the city of Barrie has even though the province is stating that the only restriction is no retail within 150 meters of a school, they have put in their recommendations 300 meters from a school, from a daycare, from a place of worship. I like those parameters, and I like those. So it may be just feedback that we give to the province that we would like tighter control and restrictions, and I would like to see that in place if the vote goes in favor, and will be voting in favor of retail for that reason, and to try and take the illegal sale of the product off of our backyards and streets.
I'm going to mirror a lot of Councillor Rosati's points. The one thing that has happened at this moment in time is the provincial and provincial government has dumped this in our lap and has created a vacuum. It said, this is now legal, you figure out how it's going to work. Now, if we sit back and do nothing, the homegrown operations are going to grow exponentially as people wish to smoke it. It's now legal, so they're going to do more of it if they wish. So in this scenario, there's no regulations, there's no controls. You don't know what the product is made of. You don't know if it's been laced with anything illegal in the process. So that creates a higher impact on our society than a controlled environment where if I've actually spoken to a lot of users, just out of curiosity to get their perspectives. And one of them told me, she goes, if I know I can spend $1 more or $5 more and go get a product and find out where it is, that it has no pesticides, that it has nothing illegal, that they can identify what the cause will happen when I go to take said product or this product. There's variations that they can use, that they go informed and that they leave with a certified product. Now, money aside, that's fine. I can appreciate the fact that we can get the money for it or not, but the idea of keeping our youth safe or our older generation safe is more important to me than a dollar amount.
Thank you. Anyone else? Councillor Van Berkel?
Yes, thank you, Your Worship. I tend to agree with Councillor Nicol and Councillor Ices. I know that it's legal, but that doesn't mean that I look at my grandchildren. I've got 7 of them. The oldest one is 19, and a couple of them are coming up close to 19. Do I want to make this accessible to them a lot easier than what it is? Sometimes the phrase, out of sight, out of mind counts. And if they walk by it and they see other people buying and smoking, I think it's an incentive for kids to do it too. And I don't entirely agree with Councillor Fowler, because I've seen it with cigarettes. When the price of cigarettes went up, people looked for alternatives. They went to reservations and bought cigarettes for half the price. And that'll happen with cannabis as well. So I am going to have to vote with the other 2 councillors and hopefully that we can leave it on hold for a little while. Thank you.
Councillor Payne?
Thank you, Madam Mayor. It sounds like a vicious circle here, but I'm not really against it, but I really don't like the idea of it being around. I don't know how we're going to police this, and to have marijuana smokers around parks and playgrounds and schools, and they're going to be around. It doesn't matter what we do, that's going to be around. I'm just, if I can be sure that the policing is going to be very good on this and really be watching and being let people know that you're out and about and you're really watching this. I too have grandchildren, and I worry about this. And like you say, you give it to them, then they want more. It doesn't matter what you give. They just want a little bit more and a little bit more. So I am concerned with that. But opting, I was quite sure as to what I was going to vote for. Opting out means that we can come in, like opt in at any time. I hope that's correct. Is that correct? We can opt in at any time. If we're opting in about the money, I think we're opting in for the wrong reasons. I don't feel good about that. So I'm going to opt out here. I'm going to just say I'm not going to agree with it, and hopefully that it's going to be for the best. And with this, it's a wait and see. But I think we just have to rely on common sense, and I hope that the residents don't abuse it. Thank you.
Councillor Nicol.
Thank you, Worship. Just a couple comments, if I might. Listening to Councillor Waters, again, Mr. Pantakainen said that the survey was quite tight, and they were quite sure that most people were only responding once. I actually looked at the survey. I was going to do it myself, and quite honestly, once I had to log in, I chose not to. So you lost my input on that anyway. So I don't know if they may have been a motivated or a very captive audience that responded, those 800 people. So I don't know that we can take that out of the 32,000 people that live in Innisfil. But anyways, to me, there's absolutely no need to opt in tonight. There are no stores in any towns less than 50,000, so we're not getting the first round of stores. Right now, all online sales are available, so it is available anywhere you want. So Mr. Fowler or Councillor Fowler, it's available. It's available everywhere anyways. It's legally available now. There will be no stores in any of these towns with 50,000 or more for months anyways. So it's not that we're racing to get to something. It's a matter of we have an opportunity now to do this correctly, rather than running in. I have no doubt that Innisfil will opt in at some point. I just don't think that tonight is the day or the time. I think it's a matter of getting our smoking bylaw in place, getting our other bylaws in place to ensure that we're protecting the residents, putting it in the right spots, whether it's commercial areas, maybe it's industrial area, whatever it is, to make sure it's in the right spot. Again, there'll be no stores for months anyways. And again, as the mayor said, there are only 4 stores between Barrie and Ottawa. So again, for us to race to try and do it just to appease whatever we're appeasing, I think we're doing it for the wrong reason. It's not about the money. Clearly, there's not enough money to even justify doing this. It's about giving the service to our residents, but let's do it properly and responsibly, and let's opt out tonight with the opportunity to opt in once we have all the other information. Thank you.
Deputy Mayor Davidson.
Thank you, Your Worship. As an employer for over 35 years in the town of Innisfil, I've hired I don't know how many 100 kids, starting at the age of about 13 and 14. As an employer, I've seen them all, pretty well 90% of them smoking pot. They can go into any school today and pick up a bag of pot. It's not impossible. Some people have their heads in the sand. They don't think it's out there. It's out there. Years ago on council, I voted against the banning of smoking in the parks. And the reason I did it, it's a law that cannot be enforced 24 hours a day, 7 days a week. You go to Innisfil Beach Park, you go to any park, you go to school grounds today, you find condoms on the back in the schoolyards and in the parks. You find needles in the school grounds and in the parks. You go to any municipal park in this town, there's a cigarette butt in the ground. So we pass laws and say, oh, we should have this law 20. If we can't enact it 24/7, and I know through the police chief, through the police department over years of being involved in this town, that they're dealing drugs in Innisfil Beach Park, and they come by boat to do it from various areas. And it's worse than marijuana. We know it's worse than that. So we can just stick our heads in the sand and say, oh, my grandchildren. By the age of grade 7, they can buy it in the schoolyard. So I think opting in, opting out, it's going to be on our doorsteps whether we like it or not. We make a few dollars this way. We get, let's say, an impact is how we want it sold. It's not going to be sold in Innisfil for the next 10 years probably. And I was asked to be an investor in opening a store the other day by a resident of Innisfil. And just basically to get a basic store going, we're looking at $1 million. So don't expect it to show up in some neighborhood in Alcona or Churchill or wherever. For $1 million, you're not going to locate in Alcona to make money. You're going to be in a major town, city to do it. So I think we need to really look at what's in front of us tonight, deal with that. If we get some revenue out of it, we have till the 22nd, I think it is. I don't know if we have another council meeting in that time. We don't. So we need to make a decision tonight as to how best to work with what's in front of us. And I'm sorry, but get your heads out of the sand.
I just want to add a couple things here. So the rules that the province has, which is the 150 meters to school, doesn't mean that we can't request that that distance be different, or that it include places of worships, or that it marries what the city of Barrie had put in for their restrictions. Having said that, AGCO does not need to follow them, but they will reply to our comments or allow us to comment on anything that comes in. My worry is if we opt out and then, pressure's put on and we opt back in at a later time, we've lost the opportunity to get the funding required for police, for bylaw, for the need that's going to be here, or that is here now, based on the online sales, based on the illegal market. So the idea, I was very much on the fence with this until I found out there's only going to be 4 issued license. So the good news story is, we aren't going to be the first on the block. The first on the block are going to be the Ottawas and the Torontos and the Londons and the Kingstons. AGCO can work out all their, they can be the guinea pigs, work out all the glitches with those, and then by the time they are ready to allow for retail under 50,000, they will have kind of got the glitches out of the system. At the same time, we would be eligible for our fair share of whatever this amount of money is. So I also think that we're going to be counted on by the province. I've been told we're going to be counted on by the province to do what we can to stop the illegal market. In Canada, one of the reasons that they gave for legalizing it in the first place is the fact that Canada has the highest consumption of cannabis for underage in the entire world. So the idea of having it sold in a retail establishment where there's serious penalties for selling it to anyone under 19 years old, and then allowing the police the ability to do what they can to look after the illegal market. And then also the Simcoe Muskoka District Health Unit is given money for education, as far as just because it's legal doesn't mean it's good for you. And the idea is to get it away from the youth, not to make it more available to the youth. So we've got two more quick questions, and then we're going to go to the recorded vote as asked for by Councillor Eisses.
Thank you, Mayor Dolan. I just want to make one comment that I forgot to mention that was in my consideration. It's not about, the idea, the option for the additional going in now is it's going to be a long time before we have a retail store here. We have time to have everything in place and parameters, but if we opt out, we don't have the option for that additional money. Police still will be required, if we opt out, to patrol our community, to have extra drug enforcement officers, and their budget, they will have to cut that money, the extra money that we get goes back into policing and bylaw and public education, which is critical for our schools. Because if not, I foresee that the police department's going to come to us in their budgets later and say, we need more money for policing and enforcement for drugs, and we're not going to have it. So that was just the one part I missed.
Thank you. I think by allowing legalization of marijuana, they was trying to get rid of the black market. By allowing us not having retail, making it a little bit easier to get quality product, we're going to just maintain the black market. We're going to have people growing pot, because you're going to be allowed to grow pot in your backyard, and they're going to be selling it to all their friends. We're not, as Councillor Fowler was suggesting, we have no control over quality in those things. Having a retail outlet that is selling quality product that everyone understands where it's coming from is to the benefit, even though we may disagree that smoking is bad for your health, is that I would rather have them smoking something that has been grown in sterile conditions and we know what's in it, as opposed to something that's been grown in somebody's backyard where we don't know what's going on. So I think it encourages getting rid of that black market in Innisfil. And I think the fact that we're not going to have a store the first round basically gives us the time to do all those things that Councillor Nicol talks about, is getting all those other bylaws in place. So I agree, 70% of the people said they want it. I think we should vote with what people of Innisfil have requested and not try to second guess, what they've asked us to do.
Thank you. I can't remember who moved this. Thank you. Councillor Fowler, I wonder if you would, if I could suggest a friendly amendment, and that would be at the end of the first paragraph to add, and that the town of Innisfil, what's the word I'm looking for? That the further restrictions, as in the Barrie City staff report, or as the Council of the City of Barrie passed, be included in our submission. Mr. Penikainen, any comments, or Mr. Scarrett?
Through you, Your Worship, perhaps just some wording. Is it it's called a municipal interest statement, I believe, is what Barrie passed to have those further restrictions. So perhaps just some wording to say that that further restrictions be identified in a municipal interest statement, perhaps without reference to Barrie, or
Okay.
that could work as well.
So I got to ask the mover if, as a friendly amendment, do you accept that as a friendly amendment?
I have no objection to it.
And who seconded it? I can't remember. Councillor Payne. What? Did you second this recommendation?
Oh, I'm sorry.
Did you? Yes, she did. So, did you second this recommendation?
Yes, I
You did? Okay. Any issues with the amendment on the recommendation? You're not required